try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage counsel to try to avoid it as much as possible. All right, now I think we're on the make and model of the suspect vehicle.
Your Honor, this is a motion where the words do matter. We're following up on that one. This seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number one. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number one. That invades the province of the jury to make that determination. The state has Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Immel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number one. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number one has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle one to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Eyewitness. It is his opinion that the suspect vehicle, captured on various surveillance video, shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video. While some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance and footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information, with other testimony and other admitted evidence and decide if they believe that that vehicle is a 2014, 2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Our request is not at this stage to limit Agent Immel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle in all of these clips. Agent Immel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips that
No.
his expertise.
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
Not actually true, as I understand it. It was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Frank's motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are in the email. It was originally, let's look at this date range. And then he said, well, I'm more comfortable with an expanded, or we need to expand the range through 2015. And that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1. And so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
Right. So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it? Good.
Yes, it was my motion.
Yeah. Sidetracked there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle one is making a specific conclusion. It's again using a term that is used within the investigation, but specifically making an argument that the various vehicles or the various images of vehicles on the various surveillance cameras is the same vehicle. Making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be right. As to the agent's ability to make that conclusion, I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes, and then we will come back. We'll shortly before 1, but no later than 1.
All rise.
Jesus.
Holy Christ. I had my speakers up so loud to hear Hitler that when you said Jesus, I
Yes,
think you brought him back.
he's coming. Yeah,
It
sorry
was that
about that.
loud, bro.
I don't know what the hell StreamYard's issue is, but it glitched out and just shut down.
That's
So-
okay. I was able to pick it up. I somehow ended up on Law and Order and I kept playing. I don't know how I even got there. I backed yours up to refresh it and it ended up over there.
Yeah. Well,
So
we're
we
back.
missed
Not everybody came back. They probably don't realize what the hell happened, but
You know, if Ann is accurate that he only increased the years of the vehicle after Kohberger was identified, if that's accurate, okay, that's damning. And she
Oh,
needs
yeah.
to make a point to the judge because his opinion of the emails is opposite hers. One of them are right. One of them are right. One of them are wrong.
yeah, after he was arrested, you're saying, right?
Right. Do we
Yeah.
remember that motion to eliminate where she was or so there was this came up, she said, in the Franks.
Yes.
We don't do
So
we have
when
any
they
of
were,
those Franks objections?
I believe so.
All right, because all I'm saying is just to the general people out there, you should be able to look into the documentations if they've been released from the Franks hearing to see if what Ann is claiming, they only changed their car opinion 14 to 15 after they identified Bryan on the 19th of December.
Yeah. Yep.
If that is accurate, then Ann is correct. If Hitler is saying no, it happened before.
That's what I think he was trying to
That's
say.
their
So,
disagreement here, but he seems to think he's dead right on it. And he may be.
he could
Right.
be. I gotta find Eddie. Do you have in your notes exactly when that happened? If at all, sir.
All right. I don't want to take sides. I don't know who's right in that dispute. One of them is though.
course.
It's either
course.
or, right?
No, of course. Wait, what's the? I think that one car image has motion blur, making it hard to see the outer edge bumper. Reflector led email to believe that it had no outer edge reflector, thus making him lean 2011 to 13 at the time. I'm not
Right, but
sure.
then he was shown. But here's the argument I've always made is that he identified two different cars in two different places.
Yeah.
Do you understand? And I've proven correct.
Yes. Eddie's
That there
gonna
was
check.
he made the determination on those videos of 11 to 13. When they got more video, then he expanded his idea could be a 14 to 16.
Agreed.
right? But the
That's what
question is, which video is he more comfortable on saying 11 to 13?
And when.
Obviously, images made him come to that conclusion, and I think you're right. Through the images they've already released to us,
Exactly.
right? And you can make that conclusion because there is no reflector on the white bumper at all.
Yep. Right. Agreed.
Right.
I do agree.
So if that's the one he's more comfortable on, then the problem begins. If it's Ridge Road that he makes the 14 to 16 expansion,
Mm-hmm.
that's problematic to understand.
Yeah, absolutely.
Right? Because he had that first video and they came out with a conclusive year.
Yes.
When do you second guess yourself on it? It was so specific what he determined, you know?
Yes, very much so.
So his credibility is kind of shot if he
Yep. Agreed.
Right?
Agreed. Eddie's looking. It'll take a little bit, but I'm
yeah,
sure
Eddie's got all that shit. He's
got every bit of the notes there, every bit of it. So
Eddie is like a walking encyclopedia.
he is very much so.
Yep.
And everything that has been anything that has been brought out in the hearings, anything has been documented, he has it in a note.
Right.
Yeah.
I don't think there's too many crazy things happening here, do you?
Do what? No, it's not too bad. Other than the fact that Hitlers were rude, there's that, but this is what you can't control that, you guys. So,
no.
Other than that, though, he hasn't really gone. I know a lot of people feel like he's leaning towards the prosecution side, only because he's not questioning them as much as he is the defense. In my opinion,
no, he hears their argument, and he makes his decision because that's how it works.
Right? He's not really gone in favor of them. If you pay attention, you guys, at all.
No.
Everything she has put forth, he's kind of given it to her thus far. He's not being very nice about it, but he's doing it. Yeah, Mama Bear, if you want to load in while they're on break, you're welcome to pull it back up. I'm sorry, I didn't touch anything. It just started winding and just shut down. I'm like, okay, here we go again. Right during the hearing, of course.
That happens to me, and I pay these people to use this stuff yearly.
Right. The rules are for they get a payment from me too, and they still screw it up. The rules are for the defense to follow, and they are just a guideline for the prosecution. Right? Yes, sir.
Well, I get a kick out of that guy saying that their lab follows procedures, and I'm thinking, well, why didn't your agents follow procedures that were set forth by other websites?
Thank you.
You know what I mean? When the procedures apply to you.
Right. So Eddie said November 26th is when the FBI expanded the date range of the Elantra, one day after MPD asked law agencies to be on the lookout for Elantra, though on December 7th, the appeal to public without that correction, aka being Sly. 100%. There you go.
So the judge is accurate then.
Yeah.
And that's okay.
All right. 12-7. I think she's referencing the fact that they were being sneaky, per se.
Well, I think that really undermines the expert, because I think what you're going to see, and this is going to be Ann's argument. Yep, he identified this is the one you were more comfortable with, and if he says yes, and it's that one we see, then you show him one that shows a taillight and the white bumper.
Yep.
Right? You see a marker light and a white bumper, and now you make a change. The change will be because of specific view. In other words, it wasn't just an ad lib. Yeah, go ahead, add on. He saw something, right? Twice. And each thing he saw, I guarantee he identified correctly.
Sure.
Watch. I've been saying that forever.
Yep.
He didn't get his first view wrong, and that's why he's saying he's more comfortable with his first observations.
It makes sense. An expert is only as good as the quality of the imagery.
Correct. That's true.
It is.
This expert's identified 2 cars.
Yeah, and that's all these experts do is specifically deal with that specific thing too. So
I think it's a red herring. I think the car and the argument is all it is. They're trying to create a circumstantial case because they have no direct evidence.
Smoke and mirrors.
That's what we're being drowned in, right? We don't even know if anybody got out of a car. Somebody could have walked in from the backyard.
Smoke and mirrors.
Snuck in the house when no one was home. There's a million ways this could have happened.
I've said for a long time back that I don't believe that they parked a car there, went in and did whoever did. I think they walked over from behind and came in. That's why they went in the back door, possibly. So,
it's as likely that somebody was welcomed in. There's no, how do you get through bedroom doors that have got locks on them?
Yeah.
There would be some evidence of that. How do you penetrate a locked door, Dago, if you're not just kicking it in? And then the noise it would make.
Agreed. Order on the defendant's motion for Frank's hearing. See, Eddie pulls it up to the damn date and page number. February 25th. What year was it, Eddie? of 20. Shit. The Franks would have been this year, 24. Or no, February 25. Sorry, bud. I see it.
All right, so that's where he's got his, and so in that hearing is where the dates are specific.
I'll pull it up for you guys to look at real fast. Hold on. Thank you,
That's
sir.
awesome, Eddie. Why is
He's
he?
on. I told you he's on point with this stuff. He's got everything in
All
anything
right.
you can imagine.
Absolutely.
All right, February of 25. 1 second.
Second month.
Yep. Order on defendant's motion for Frank's hearing. Yep, there it is. So all I got to do now is go to this one here, page 18. Are you serious? What an
Sweet.
ass. I'm an idiot. Sorry.
Present.
Tried to-
Remember, you
I'm
had
an
to keep
idiot. I
track.
clicked on the wrong one.
Got to be 220.
Never
whatever.
failed.
225.
Yep.
Got to go down more.
Oh, it'll bring it up for me. There's 218.
Go up. Wait, you're going to.
2. Wait,
24 and 28. Where's the 25? February 19th. No, hearing 19th, February 25. 19.
February 19th. Thank you, Ed. Sorry. I was down there. I was right. Sorry. Anyway,
Sorry about that. I read it differently.
it's all right.
That's
It's
how
right
we-
here. Here we
right?
go. Page 18. That's what I was looking at. Let me blow that up for you guys. Scroll on down.
Boy, I didn't get in the way on that one.
Shit happens. No big deal. Good Lord. Why am I doing this? There we go. All right. So these emails demonstrate that it was Agent Email's decision to open the date range to 2011 to 2016, despite his preference for 2011-2013. Exhibit A accurately captured the decision by stating that the specialist initially believed it was a 2011 through 13, but opened it up to an 11 through 16 upon further review. While Exhibit A did not call out that Agent Email preferred narrower time frame, defendant has not shown this omission to be exculpatory, and material Exhibit A is replete with evidence linking defendant's vehicle and cell phone to suspect 1. Considered as a whole, it can not be reasonably concluded that Agent Email's preference for a narrow date range would have derailed the magistrate's findings of probable cause had it been included. Probable cause is not an exact science and does not require that law enforcement establish with absolute certainty that the facts alleged in search warrant affidavits are fact true. Simply because Agent Email may have felt more comfortable with earlier years within the range he provided does not mean he felt uncomfortable with the later years. Thus, it is highly unlikely the magistrate would have disregarded the specialist's identification of the larger date range.
It's the first sentence in the top of page 18. What's the first sentence at the top of this page?
Not support his argument. What the email chain shows that November 26 to 22, Agent Email directed the FBI to open up their search through 11 to 16.
Yeah.
Bingo.
So that's what I mean. It's documented. We trust that he was right. Thanks for the document too, right?
Oh, yeah. Eddie's always on point. Thank you, sir. Always appreciated. He's an amazing resource. We're grateful to have him here. Yep. That's it right there. It says it all. Thank you, sir. Once again. All right, guys. Share this out if you will. Let everybody know we're still here. Again, my apologies for that disconnect. I hate StreamYard sometimes. They just stupid shit. All right. Well, we'll see what happens with that. For sure.
Right.
Which way he feels he goes. 2014-16 on December 20th. Okay. Now I feel like I said, I
Wait,
feel
what was the date? November 26th?
yeah, November 26th.
Well, didn't Officer Payne also testify that Bryan was on the radar earlier, yet excluded?
Mm-hmm.
So how does the expansion of the year? I mean, so on what basis would they have excluded him if it wasn't for the wrong car,
That's
or they didn't look into him, or something? It was not.
I think they didn't look into him, unless I could be wrong. Let's see that means that it was done in an underhanded way in an email chain internally, but not to public.
Yeah. Why they didn't revise that and include more years for the public's help?
Exactly.
But it may also have been because they were getting people didn't even look at the year, make, model. Just told people that my neighbor got a white Elantra.
You're right.
Right.
There was also in the state's documents that they expanded it from 11 to 16 on the 26th, but the first time they stated 2014 through 16 was 12/20 in the state's document. What document was that, Yvonne? Because if it went back that far.
Yeah. No. What she's showing, read what she's saying, and that agrees with Ann.
It was also state's document. But the first time, oh, yeah.
But the first time they started to look for your make models was after they identified Bryan.
Exactly.
And that's what Ann is trying to show here. But
yep.
I don't think that that's something you're going to get excluded. I mean, how do you
Probably
exclude
not.
that?
He'll probably say it's irrelevant.
No, getting it to exclude it actually is, in my opinion, a benefit to the defense anyway.
Should be.
Right? I mean,
agree.
in fact, the guy identified 2 cars and he preferred the 11 to 13. And then when she goes into the description of the phone's travel, now she shows it's consistent with a car that they began their tracking of, even knowing you could track Bryan driving south. In other words, it was a different 4-door sedan they tracked.
Mm-hmm.
Right? That missing 2 minutes or 7 minutes in the beginning.
Yep.
Agreed. So I don't think this hurts him. Or it's got to be, hashed out.
Right. Well, there's AR.
I can't see anybody joining over here. Crime spy.
He's in the courtroom.
Oh, I'm sorry.
Hold on.
I cannot see the courtroom. What do you think, Dago? You think this is fair, or you think it's unfair?
Officers do a little bit of scattering, and
Hold
then
on here.
they directly pointed at Jen and I because we disturbed the courtroom, but we survived that. We made it through. But literally, Bryan Kohberger, in watching him, and ladies and gentlemen, I want you to understand, looking at him from behind, he's not as small as what people make him out to be. He is very broad-shouldered. He looks to be in relatively good health. That picture that came out, that is the so-called selfie, that is not the same Bryan Kohberger that's sitting in the courtroom. That is an absolutely doctored photo. That is not real. It does not look like the same individual. When Bryan Kohberger turns towards you and you see the facial features within him, he still looks young. He looks healthy. I mean, his hair almost looks like it's actually taken care of better than mine, and I'm on the streets.
Yeah, I will say, though, like, just sitting in the courtroom, it 100%, in my opinion, feels like the judge has already made up his mind and he's shutting down everything that the defense is requesting. You can see in his face expression and in his eyes that his decision is already made before they even present their argument into why they're filing for these different motions.
Okay, so I don't want to
see it
run
that
too
way.
much of that without his permission. I just wanted to show you guys he was there doing his
I'm
thing.
not sure I agree with that because
I don't-
what Hitler's doing is threading the needle, right?
Right. I
He
think
doesn't want you to use touch DNA or contact DNA. He wants them to use transfer DNA. He's not going to order that but he's saying that he doesn't want people to, if they slip, there's going to be no punishment, but they're
I
going to
think
go transfer.
I think because of his personality, Sarge, and the
Yeah.
persona that he's presenting to the world, I mean, he has approved, okay, more than he's denied. Obviously, I don't think I've
I
seen him
haven't seen him
deny
deny anything,
deny
actually. What I've
anything.
seen him do is approve, and then where things he's taken under advisement. One of the things he was taken under advisement. Well, even this argument that Ann made, we just saw Ann made a big mistake. She has her dates wrong.
Yeah,
She is correct that they only looked at Bryan Kohberger after they identified him to include the 14 to 16, but that came, a month and a half before they even, in other words, they
right.
had identified that year car a month and a half earlier. She made a mistake there.
Yeah, but I will agree. He does seem to be more. His personality is more favorable towards the defense. He's treating them nicer, but he's agreeing with, or I mean, towards the prosecution. He's being nicer to the prosecution, but he's not. He's not disagreeing with the defense. He's just arguing.
Correct.
So
That's
it
what I
does
said.
come across that way. Yes, I agree with that.
And
Okay,
if
he's not
you listen to his rulings, they're pretty cut and dry, and they shouldn't surprise anybody.
right.
Right?
I mean, he's giving the defense the things that they're asking for, but he's being an asshole about it. I'm just put it in layman's terms. Period. He's got to argue the point. Everything that they say, he's calling it out. He hasn't said 2 words to the prosecution about anything they've said. So
Well, that's the side that's putting everybody under pressure at this point. I mean, this is how a system is supposed to work. And I'm sure that if you're, he says he's had 100 trials, he's had 100 defense attorneys tell him what can be and what can't be, and then try to present case law to argue that this is the way you must rule. And after, putting up with that for so many years, I'm not so sure you wouldn't, maybe have some inner, like, with these defense attorneys.
right.
Right? Or he may just be not liking Ann Taylor. They may have personal, connection we don't know about, or a professional connection that has friction. What do we? But as long as he's ruling fairly, who cares what he looks like and what he said, how he acts? Right?
Agreed.
I mean, look at the leeway people give me. Right?
That's a whole different.
No, I'm just using that as a good example, though. Listen to the substance, forget his personality, because the substance seems very reasonable to me.
Yeah, I agree. I can see what everybody's seeing with him. He is being an ass, but he's giving them what they need to that extent.
Yeah, I think
it's not right.
On the ticket video, that ruling was right down the middle.
That one I agree with too.
There was no need to show a whole video of a traffic stop to infer this is the kid, this is the car, this is his license, this is his phone. You didn't need that video, and he's not allowing the video. So
right,
and that helps crush the state's circumstantial arguments.
Mm-hmm.
They're not going to have it to pay. You've seen them at the traffic stop. They're not going to be able to refer to that.
No,
so
not at all.
He's being fair.
Yeah, like I said, he's doing what he's supposed to be doing. He's just being an asshole about it. That's all.
Yeah, I'm an asshole about
whatever his reasoning for that is, whether it's because he prefers the prosecution, so be it. But he's still got to do what he's got to do. He can't
doing the right thing. It appears at this point, and everything that's been put in front of him.
Yeah.
No. Does the prosecution have motions in limine? I don't know.
I haven't even
been on this so long. I don't even know what is today.
Right. Hang on here.
Again, now we got to sit through their lunch.
Oh yeah.
We're all starving. Where's my steak?
Go get yourself some food. So I'm surprised you haven't been eating yet.
Nah, I'm fine. I got chicken. I made enough chicken for 2 days meal.
Oh, there you go.
Yeah, we're
What
good.
kind of chicken did you make?
I like chicken thighs, and I roast them and bread them, and I didn't bread these, and some stovetop stuffing. And then I cut all the pieces. I cut all the chicken into pieces and just mix it into the stovetop stuffing.
Please tell me you use gravy.
No. Well, no, but yeah, the what builds up in the pan, I pour over it.
Okay, at least that works.
Yeah. I make the stovetop with that as well. Or if I'm making mashed potatoes, I mix the broth or whatever I'm cooking in with them.
Mm-hmm.
Yeah. So listen, I think people observing him for who he is rather than what he's saying, you can't discount their point.
Mm-mm.
Right. I mean, so I'm not saying that people are wrong in their observation of the guy's personality and his behavior.
No,
I am seeing though a more set of fair rulings than I expected from the guy.
Yeah, I agree with that one. I expected he would shoot down everything she said.
Right.
I truly did. And he's not doing that, which is really kind of surprising me. Regardless of him being an ass and interrupting her and blowing things up, pushing things off, talking down. So what? Who
Look
cares?
at Jesse. Jesse says Hitler is a guilter.
I think he is to an extent too. Like, but his personal opinion could portray why his personality is the way it is. If he feels like he's guilty, that's great, but he can't show that. You know what I mean? So,
listen, I don't know if I wouldn't want to work in the criminal justice system in any capacity. You got to lose your mind, man. Dealing with all kinds of people.
SRB. And again, guys, don't forget the guy did not want this case, so I'm sure he's aggravated about every bit of this case. He's already talking about how you're not going to be arguing. He ain't gonna have that. I'm not gonna put up with that one, which I can see. I just don't think he wants to bother.
I can't wait till they cross-examine that woman that's going to tell you that the amount shows when and where.
Right.
The amount shows, he had to have touched it, and it had to have been during the crime scene because we found it on the knife. I want to see her support that with proof.
Right. Oh, Jesus, Jesse, that was funny. Hitler, Gray Hughes, and Jeff walked into a bar.
Oh, God. None of them drinking. They all burst out into tears.
Yeah. You guys are rough. You guys are rough. Jeff even jumped into it. Jesse, the Guilter Squad. Yep. I don't get Gray's portrayal on some of this stuff ever. I don't understand the man, how he thinks. It doesn't make sense to me, but it is what it is.
It's sensationalism, and it's
it is.
It's drama. Right?
Wait a minute. What are you saying? He didn't shoot down anything, Eddie. Everything that the defense put out there, he agreed to it. He may have altered it a little bit, but he did agree to it.
Yeah, I don't know what he shot down. And when it came to the traffic stop to identify Kohberger, I don't think he did anything. He took the video out of the equation.
Yeah, he said no to that. And in the very beginning, he said, what was the first thing he put out there? They put out there the first
even on the DNA being called transfer. Both sides have agreed to maintain that, and if they slip, there'll be no punishment.
Yeah, he's not.
So he's not giving the prosecution all those weapons. I mean,
now I could be wrong, and he's sounding one way now, and come document time, it'll be different, and that's when I'll go back and say, okay, he's a complete asshole.
Yeah, but then she would have to approach the bench, and there'd be an interruption. I think he's being as fair as he can be, considering the case in front of him.
At least it's
whether we want the guy to be guilty or we want him to be innocent shouldn't matter.
Yeah,
it really comes down to, is Hitler being as fair as possible? And I don't see anybody. Maybe Eddie is noticing something. You'll see.
I think it's because he's not blatantly agreeing with the defense, and he's arguing the points, it seems like he's trying to shut the defense down with what they're saying, but in turn, he's not really doing it. He's just altering what they're saying and saying it in his way, I guess, for lack of a better way to put it. We'll see in the documentation when it's done. When the ruling's done, it'll tell the truth on that, and we'll see at that point. And maybe I'm wrong, but
no, Jesse's making a good point. Read that.
It feels like the state is asking the court to trust us. Of course they are.
But the state is agreeing with his interpretation of what's going to happen. So I agree with what you're saying, Jesse. However, before he concludes this particular little interval of whatever the issue is, the state is affirming what the judge is stating. And so the state is on the record of affirming that.
That's it, right there.
You're not going to show the whole video. You're not going to allude to that.
And
blah, blah, blah. So
we're to take their word for it at this point that they're going to agree to these things. Now, if it comes down and they don't, then he better sure as hell call them out on that.
Well, at that point, she can object.
Yes. Absolutely.
She can object, Your Honor. Can we approach? And she'll remind the court of these particular orders that he made today.
I pulled down AR's video because I didn't ask his permission to put it up. I haven't spoke with him yet today, Eddie, and I don't want to be disrespectful because he wouldn't do that to me. That's all.
No, it's good you did, though. It's cool. It's good that he's there. And like I said,
I just wanted to show you guys that he was there. I told him that I would make sure everybody knew he was there in person.
The one thing that disturbs me that nobody's talked about, I don't know how everybody's missed this, is Bicca Barlow surrendered to the FBI's work in the genealogy to being a tip.
Yes.
The defense surrendered to that argument. I don't know I don't know how everybody's missed that. But that to me, that's the biggest take I'm getting from this. The other stuff doesn't seem that impressive or important to me. He's doing the best he can with what he has. And it seems reasonable. You're muted, Dig.
I'm here.
Oh, I'm sorry. Oh, okay, I'm sorry. I'm looking at YouTube.
It's okay.
Yeah. So to me, that's a big deal that they're going to allow the FBI work to be a tip.
Right. Yeah, I hope. Like I said, I hope that I'm not seeing this one way and then it turns out to be a different way, because at that point, then I'll have to turn around and say, hey, this is a problem.
Right. You answered one made nut, right?
Yeah, I did. Did you hear me? Did you not? Did you guys not hear me say that or no?
Well, I'm backwards over here. I'm sorry. Yeah, I know you said something in reference to that.
Right. Yeah.
I just seen the comment and I'm like, that sounded familiar. That's why I asked.
Here's the thing. It's called streaming snipe. When somebody's live and you're streaming them while they're live without talking to them or having their permission, which I know he would not mind, but I'm just being respectful because he would do the same to me.
Yeah.
I don't want to. It's basically
right. He's spending the time to go down there. They're actually there in the courtroom.
Yeah.
You don't want to just jap the guy's video and
right.
It's up for him to broadcast. You took a piece of it which was on break, so and they voiced some opinion, but that he's going to have a big stream on all of that.
Yeah,
views and whatever.
If I could speak to him while he's in here and say, "Hey, buddy, we're live. Do you mind if I show you while we're live?" That'd be different. But I said something to him in there. He didn't respond yet.
No, that's fair, Dave. Of course, be fair.
I'm just trying to do the right thing. That's all.
Yeah, just trying to be fair in life. That's all. And that's kind of the whole basis of the justice system. It's supposed to, and I see it in action with Hitler, whether people like his decisions or not. I think he's doing the best he can with the laws that are written, and
he's in a grocery store.
He's not preventing Kohberger from a third-party defense. Not even close. Not preventing that at all.
That hasn't come down to it yet, right?
There's rules that were in place that have nothing to do with Hitler that allows you to provide that defense and under the terms and conditions of complying with the code or the law, right?
Yeah.
You just can't all of a sudden say Sergeant Friday on YouTube did it. You just can't throw shit in the wind when you make a third-party defense. It has to be directly relevant and information has to be, verifiable. So,
that is true. That is true.
But that's not his rule. That's the state law. So he ruled properly there, I think.
Right. Yeah. And by the way, AR is in a grocery store right now. Anyway, guys, he's not doing.
Is he?
Yeah, he's not doing anything of any importance, really. They're just walking.
Don't wear gloves so he don't transfer his DNA.
Yeah. I don't know what. I think he got a new. He got his phone number changed out, and we don't have each other's numbers anymore. So. I went to look to call him and I don't have it anymore.
That's all right. I'm probably going to jump out of here in a few minutes anyway, but I think it's been great, Diego.
Those so far have been interesting.
They're moving through. Sure. Yeah, it's like anything. We were looking at, I'm not used to seeing the day before the month in the year, 19 February 2025. It's February 19, 2025. So when I was looking at his thing, I didn't know what the hell I was looking at.
Yes, sir.
We get a good get the parents to travel. Yeah, I think on all these minor hearings, I think they're fine when it comes to the trial itself. I think they can't be there for all these minor hearings, and I don't.
Yeah. Because of the money it would cost them to have to go, fly, stay, and then fly back. You know what I mean?
These are pretrial hearings anyways, motions. And,
yeah, they don't make a whole ton of money, either one of them. So
they're being there is not going to change anything. The judge doesn't care if the parents are there or not. He's there to rule on the law. Right? Exactly. He's not going to make the decision whether this kid's innocent or guilty. So Kohberger could have a courtroom full of clowns and the judge couldn't really make any opinion of that. It's none of that business, right?
Right.
Clowns of America support Kohberger.
Yeah. 100%. Hold on here.
That'd be awesome.
Oh shoot, Mama Bear. Sorry. Forgot
What'd
to
you
give
do,
you the
boot
new.
her?
No, when the thing shut down, it shut her down, and I forgot to give her a new damn link. There we go. Sorry if you can hear me. It's in there, Bear. All right.
Well,
Exactly.
I'm gonna
Exactly.
jump.
Go ahead.
And
Go ahead.
thank you for having me up here. I'm glad we saw what we saw, and I'll talk to you later.
Absolutely, sir. No problem.
Everybody be good.
You too, sir. You too. Enjoy your lunch. All right. There you go, Mama Bear. Please hit them like buttons, guys. I'm sorry for all the mess that happened. I have no control over StreamYard, but they do that to me all the time. I just wish they would pick days unlike today. Oh, his stream's not even rolling now because he can't get a good signal. Well, shit, dude, that sucks. I get that feeling sometimes too. I understand it completely. Let me put this up here at least to get that ready again. Hold on. Okay, we're ready there. Now, I guess I could probably pin a link here. If anybody wants to discuss anything, we can do that. Give me one moment. Hold on a minute here. Let me move this over. There. If anybody wants to pop up here, at least while they're through lunch, we can definitely discuss different things if you want. If not, no worries. I appreciate you guys. For those of you that came back, I appreciate that very much. Again, my apologies that even happened. And that's a huge point. His parents aren't going to go grifting money just so that they can get across the country. But that's a great point, Candy. I'm surprised nobody did start a GoFundMe for them to be able to be there, but it didn't happen. So I'm sure that would have been torn apart too if that happened. Oh, okay, Eddie, I see you, bud. No problem. Be careful, SRB. Thank you, Alicia. I mean, I think his family deserves and should be there 100%. They're going through their own version of horror, per se. They could possibly lose, their son and their brother to the death penalty if this goes the wrong direction. That's a horrific thing to any family. I see you, Miss Paula. Thank you for being here with us. Who is sitting right behind the defense team? I wasn't really looking, Yvonne. I know that Twiz was sitting in the back against the wall in the corner, and Twizzle, and that AR and his wife Jen were sitting 2 people down from him in the same row. I don't know who else was there. I didn't recognize anybody else right off the gate. Thank you, Josie. Good to see you. I hope you had a great day for your birthday yesterday, Josie. Yeah, and that's a good point too, Josie. They should be able to do a GoFundMe for a situation, but they'll be destroyed by everybody, all the guilters that swear up and down, oh, look at what they're doing now. It'd be a disgrace, They have the right to be there too. So a lot of people helped the Gonzalez family to be able to get there for their travel expenses, I think that's fair on both sides to that point. Oh, right behind Anne is I don't even know. I'm trying to think of who was sitting there. I'll have to look when we go back, Yvonne, and I could try to let you know that way. There he is. Edward, welcome back, my friend. Good to see you today.
Thank you for having me up.
Oh, every time, you know better. You have
And
you have your own seat here with your name on it, buddy.
thank you. And moments ago, I hope I didn't put you on the spot. I didn't mean to.
With what?
That wasn't my intent. So I kind of challenged you a little bit, saying,
Oh, about AR?
did you,
Oh,
yeah,
don't
did
worry about
you
that. No,
truly not play any more of AR Hayes' video because of this reason, or was it for this other reason? So
no, I just
I hope I
truly,
didn't,
here's the
come
thing.
across.
No, you didn't. I know you better than that. Me and him went through a little tip at one point, okay? And we've repaired our relationship since then. I didn't formally get to say, hey, buddy, if you're there, do you mind if I play your stream? And he would have asked me. We've been respecting each other quite differently lately, and I just want to do the right thing. It's called, there's a thing where people will play other people's while they're live, and it's just not morally right. So if I had the ability, because I did talk to him in his chat to see if he'd respond. I didn't get a chance. He didn't say nothing to me. And he's having bad connection issues right now too. So if he would have said, hey, what's up? Go ahead, this and that, that'd have been different. But I didn't get the approval, and I don't want to step on his toes that way. So
Is he married, or does he have a fiance? Or
Jen,
he's married.
Jen, that if you could see him sit in the back there, the woman with the white vest on is his wife, Jen.
Okay, so that's what I thought. She was talking facts right when you turned her off. She was saying,
go ahead.
Her takeaway is that he's already made his mind up. And, I think it was a couple evenings ago we were on the panel together, and I forget what you were saying, but I said, now hold that thought and then combine that thought with this. And in the this that I wanted you to combine the thought to was his rulings on the Franks order, his orders for the Franks hearing, which I believe, I don't want to put words in your mouth, but if I recall, your opinion on that is that, because I said, was his rulings, was it that Anne made a bad argument and his rulings were correct, or was his rulings inconsistent with her argument? And it seems like there's more going on here. Like this is
I definitely stated that I think Anne made a perfect argument. I think that I felt at that time that he probably ruled in the wrong direction, in my opinion, for whatever reason. Now,
like it's a biased ruling.
I agreed with that. I still feel like he's biased. Okay.
And I said, now let me complete my entire thought. And I said, now, if in this upcoming motions in limine hearing, if his rulings put together are the same or similar with his rulings with the Franks hearings and with what you just said, putting it all together, then by that time, we will be able to know what is going on.
Okay. Yeah. To some extent, 100%. Sure.
Sure. I mean, there's a point you can, how does Southern logic put it? You can only stack coincidences so high.
Yeah. Right.
There's a point at which it's got to click.
Yeah. I agree.
Mean, how blind, we can lie to ourselves and make a fool out of, our own selves for our way of thinking. But, when all the facts are right there for you to read, there's a point at which,
and I agree with you to an extent on that, Eddie. I do. And what, no disrespect intended for what I'm going to say, but there are certain rules he has to follow no matter what, which we know. Okay. I think personally that he very well could be leaning more on like his own personal opinion, which he can't put out there. We know that could be that he thinks Bryan's guilty. There's no two ways about, he's coming off with an attitude toward the defense. I see that in my opinion. Maybe people disagree. I don't. I think he is. But he cannot allow, because it will be called out. okay, people will see it, people will call it out. He cannot allow his personal opinion to interfere with what he's doing with this, is what I'm saying, because otherwise, at some point, they're going to say, yo, what's going on here? This, you can't do this. You know what I'm saying? And they're going to look into that. But I do know that there's certain things he has to do regardless, and rule wise. And I feel like they haven't been ruled on yet, but he's somewhat agreed with most everything she talked about. Changing up, he argued, yes, he did argue her points. Most everything they said, he argued it, but he also changed it up a little and adapted it to where it fits both. Okay, and I think that's what he's trying to do to an extent. I don't know.
Well,
that's my opinion.
He has already ruled on it. And what Jen was saying is that he is easy to read. You can tell the way he's going to be ruling, certainly. Now, there's going to be many, many points that he's going to rule on, many motions in limine here that they're going to discuss and that he'll rule on. Now, let's say, I'm not saying that it's going to be 100-0, but let's rank motions in limine. Let's say that this is the most important. This is one that we just have to win, and and just rank them, 1 through 10, on a scale like that. And then this one, okay, if we lost that one, well, it's, it stings and it's not good for our cause. But if we're going to lose one, I'd prefer to lose that one,
Of course.
Because that one ranks lower. So am I saying that he's ruling, 100-0 in favor of the state? No, because that's too conspicuous. See, it's, he's going to find some middle ground, kind of like that, that August 21st traffic stop. Maybe there will be some portions of it that are edited out, redacted. And is that to be viewed as a victory for Ann? Well, I guess.
Well, not really.
Be like
it's not a loss, but it's not really a victory, right?
But you can just tell by, like what Jen was saying, you can tell by the way things are going in the courtroom which way it's going to be going.
I get that feeling, but I'm going to give, and I'm just saying, that's why I'm saying it like I am. I'm going to give it the benefit of the doubt to wait to see the ruling. Now, when the ruling comes through, and if it goes with what you're saying, then I'm going to wholeheartedly call that out, period. Okay? But I'm going to give the benefit of the doubt until we get to the point where he rules on these things and see what he says. Now, if he goes exactly down that path that a lot of people are saying he is, then I'm going to sit right with you and say, there it is, folks. He's already made his decision and he's biased. I'll agree with that. But I'm going to wait till he rules. That's all I'm saying.
Yeah.
When he does, now, if he rules the opposite and he does rule in favor of the defense, okay, there's going to be some question to that. I'll say that much. But I have no doubt the man, in my opinion, has some sort of a biased feeling towards this, and that he's got a bit of a, for lack of better terms, a bit of a hard on for the defense. I don't think he likes them very much. That's my opinion, of course. And I think it's because he doesn't like the case, guys. I don't think he wanted this case. He clearly said he didn't want nothing to do with it. So we'll see, though. We'll see, though. You may be 100% right, Eddie. Okay.
Well, he doesn't like the case. There's no dispute there, because maybe you and I, for the reason because, might be different. Whatever you're thinking, his reason might be, and mine might be different. I believe it's because he has had like a briefing, we'll say, prior to taking this case, and he's been directed as to how it's going to be going, how this is going to go forward, right?
Okay. I understand what you're saying. Yeah, I get it.
Yeah, there's no way to prove it. But, with any argument, of course, he has to, remain within the boundaries, and is going to have to adhere to case law and law in general and all that. But, with a team of, like, I don't know how to describe it. In my mind, he's going to have the support of a team an army of federal lawyers that are just excellent at making an argument for anything,
Mm-hmm.
regardless of what it is. They can make a good showing of it on paper, for how, lack of better words, if it's a wrong ruling, it may not come across on paper that it is wrong,
Right.
even though it is wrong.
No, I understand what you're saying. I get it.
And, of course, the other side, the guilters are going to say, oh, if only Anne did better. She keeps losing her arguments. And no,
Mhm.
it has nothing to do with this. So that's why I take exception whenever people, woulda, shoulda, coulda with Anne.
I
Because
understand.
that's just a mischaracterization of what's going on here. And if people say that, it's kind of reckless, and it brings us further from being able to identify what is truly happening in this case.
Hopefully, if that's the case, it can be seen for what it is, if that's it, and called out. And I don't think it would be. If that's truly how things are going down, it's going to go by the wayside. That's how I see that happening. If that's true, if it's just a complete, total misrepresentation of the way the law should be because of laziness, ignorance, stupidity, and things like that, that's different. But we'll see. I'm leaning on one side. I'm not going to clarify yet how I feel until I see some other things that I'm waiting to see. I have a big, strong feeling, and I'm leaning in one direction really strong, guys, as I said the other day. I just need to see a few more things that could fully clarify that for me before I can make that full judgment. That's just who I am. So, but I do have some very uncomfortable thoughts with this. I'll put it that way. I really do. I'm not by any means comfortable with the way things have gone here at all. This guy, well, this part of this, as far as the trial, the hearings and all that, he's under the spotlight of the whole world. Everybody's watching him. And like I said earlier, there are certain rules that he has to abide by, period. No matter what you do, you can't get around that. Okay. He can try. If he was trying to, he can try, but there's too many of us that are watching this that are going to say, yo, like, what is going on, and call people and say, this is not right. And people are going to be paying attention to this in higher up positions at some point. And if it's wrong, they're going to get it. That's all I see that, they will catch that, and somebody will do something about it. Whether it's the Department of Justice or what, but at that point, but until those things come down, I'm just kind of laying back a little bit and watching how this happens. Mainly right now, I'm waiting to see how these rulings come through. That's partially how this is, with everything we've seen recently and the things that I've come to the comfort zone with now. Based on how he starts to rule on these things, we're gonna have to go there and say, hey, something ain't right with this. Okay. And
I agree.
There's something going on, I'll say for sure. Okay, there's something going on. And it's definitely a bigger problem than what we're seeing. Okay.
You recall the other morning, I think I asked you about the Delphi 3. We talked about that briefly. And
the West Memphis 3. Yeah.
West Memphis. Yeah, sorry.
It's okay. I seen Delphi in chat. Yeah, I got you.
The hazards of reading and speaking.
It's all good. You're good. But I just
yeah, the West Memphis 3. I always hesitate to, when talking about this case, bring another case, because people may not be familiar with it. But I think, just in general, if we were to talk about the West Memphis 3 and how it turned out, we'd both be in agreement that justice was not served initially, that they framed 3 innocent teens. Now, with hindsight, of course, we know that, right?
Mm-hmm. Yes, sir. Yes, sir.
But that was not the opinion in that moment when it was happening.
No, of course not. Of course not. No.
Yeah. So
Well, you saw Eddie. Did you notice that they brought up the case that I presented to you guys yesterday, the State versus Meister case that I showed? They brought that up right there earlier in the hearing.
Oh yeah, that's right.
So there's somebody's paying attention, okay, and there's point right there. Whether or not he allows that, I don't know. He argued that again, like he argues everything thus far with the defense, and that is what it is. But it's there. It's in people's eyes and ears now. You know what I mean? And in their head, that this is something that's happened before. And I'm sure the other case will get thrown out there at some point too, and say, "Hey, remember this too? There's something not right here." So I'm real curious. I am.
Agnes Kaufman made a comment, and I kind of agree with it. She says, "I don't think the defense is doing well today. They aren't strong speaking at all."
No, she came off a bit. They came off kind of nervous, I noticed, and I think Tomboy picked that out too. But then there again, the man is not. He shuts them down when they start talking. He shuts them off, and
That's
then
what I was gonna say. Like if you're constantly browbeaten,
yes,
right?
yes,
It's
you're
gonna
gonna fail.
derail you. You got a
Absolutely.
rhythm. You're trying to, you're
Absolutely.
trying to speak eloquently and keep your train of thought.
And he's
And
had the
when you're
back.
constantly derailed, and Santa's over there coughing whenever the defense is speaking, but not when the state litigators are up there, and the whole thing put together can really kind of undermine, right?
100%. Yes, sir. Anyway, we've seen it every time. There's an interruption or there's something else, but they don't do that to the prosecution, and that bothers me. Okay, they definitely don't do that to the prosecution. He does not interrupt them. I don't know. The only person he didn't seem to interrupt really was Vika. He didn't really interrupt her, but anytime Alyssa started speaking, he shut it off. Anytime Ann speaks, he shut it off. She said, "Let me back up here, Judge. Let me back up here, Judge." It's a problem. It's not. It's disrespectful. I'm sorry.
And Jesse is right. I don't mean to judge when it comes to speaking. I don't mean to judge anybody.
Could have spoken better. I agree.
Yeah, Jesse is,
and she
hitting it right in the center of the target.
She is, Jesse. She's very good at what she does. She's very smart, but she didn't portray that very well to me. And that's just my opinion. And you can see that's another thing. Now think about this, you guys. If you're standing in front of somebody that's already intimidating, a judge, and you're trying to explain to him, which I that's one thing I like about, as much as I don't care for her, Alyssa Massow, that she doesn't get intimidated by that. And kind of does, I think. You're telling this judge what you're presenting to him, and he's sitting there doing this. Or while you're talking, he's looking down here going through papers. That's disrespectful. And that, in my opinion, shuts down the person that's presenting this to you, their confidence. Anybody can say I'm full of shit, and I'm going to tell you you're lying. Okay? Anyway, I don't care if you do it 20 times a day. Somebody that is speaking in his position in that sense right there, in that fashion, when you make it seem like what they're saying is unimportant, they're going to react that way, folks. And it's going to come off that way. And it's very disheartening. And it happens to her constantly.
There's been a study on that. It is called The Art of Listening.
Of course.
Yeah. If you behave as a listener in a way that kind of exhibits that you do not welcome to hear what that person is saying, it's going to bring about less of a well-put communication. It's going to come across not as clear, well-spoken,
right,
as it otherwise would if you were actively and politely listening.
If you felt like you were being heard. Yes.
That's right.
And here's the thing, Dan is absolutely right. This is something I truly feel, guys. He's listening. He's listening to the things he can pick apart. And that's the only time he'll speak up. When he can grab something to shred, like Dan said here, you're going to hear him talk. Until then, he's just, "Oh, you done yet?" That's the personality he's showing them. That's what I would take from this. Sitting here like this, looking up, rolling around. If you're tired, go to bed earlier, sir. Otherwise, you need to sit up straight and be attentive to the person speaking to you. That's your job as a judge. Give me 1 second, guys.
I think a good way to describe it might be smug. I'm looking it up right now, by the way. No, that's not the best word. Smug is not it. Not quite it. There's got to be a better word, but you get the point. He's kind of coming across uninterested. Maybe that's better. Glib. I like that. I bet that's more to the point.
All right, that was the boss lady. But
I'm
that's a
trying to
great.
find a descriptive word for the way he, comes across. His
Cocky, arrogant.
yeah. We were
I
talking smug, and that's not quite it.
I think it-
Disinterested, glib.
think it. Oh, definitely disinterested, but I think it's an arrogance. Almost. It gives me that feeling. Welcome, Tandy. Which I don't understand an arrogance. We know you're a judge. Great. I get that. I respect that. You don't have to. It just seems like he's bored and irritated. And again, the irritated, sure, I get it. You don't want the case, but you got it now. Deal with it. You need to show professionalism at this point and present yourself as a judge and not an aggravated teenager that doesn't want to be here to do this. Because that's how I see it. It's a mixture for sure. Not single source, Hitler's attitude and approach. Yes, sir. Yes,
But yeah,
sir.
it's, if we use history as our guide and look at the hearing on January 23rd and 24th,
Mhm.
and his body language during each of the argument points, and then his rulings for each of those arguments, you will see that they're consistent.
Mhm.
And this is just, kind of like Groundhog's Day. He's doing it again. He wears his emotions on his sleeve. You can read them easily. And Jen was right. We already know the way he's going to rule because his mind is already made up before the argument was even stated.
It's a good point. Oh, shoot. And we're back. Okay.
Okay, I'll hop.
You're welcome to sit here, buddy, if you want. Just mute.
Okay,
That's
I'll
fine.
mute.
She eyebrows, I think, is next. This is
We're going into eyebrows next.
DM is considered an eyewitness. And eyewitness testimony is some of, if not the most impactful testimony in a trial. The testimony must be subject to close scrutiny before its admission is allowed. We seek that the use of the descriptor, bushy eyebrows, be excluded from use at trial because the witness with this descriptor is completely uncertain of what she remembers, and her description is derived from seeing the intruder for only a second. Whether this court applies Manson-Biggers, which I would say is not completely right on point because there wasn't a photo lineup and there wasn't a show up, or the court considers the science behind memory, the criteria you must look at is what factors influence the accuracy of the memory and make the testimony reliable, because reliability is the linchpin in determining the admissibility of identification testimony. Between Manson-Biggers and the science of memory, there are several factors that are consistently considered, and I'm going to go through a few of those. Factor one, what was the opportunity to see? This is also known as first phase of development of memory or the acquisition phase, and distance, lighting, and duration of exposure are important. DM is uncertain about the lighting. The stairs to her left were not lit. The kitchen may or may not have been lit. And the twinkle lights in the living room may have been lit. She described seeing the person for, quote, only a second, end quote. The person may have been 3 feet from her, or he may have been walking to exit out the back sliding glass door. The back door is further than 3 feet from her door and is not visible from where she was standing. We submitted 2 pictures as our exhibits to show you the vantage point of where she was standing in her bedroom. Her opportunity to see supports unreliability. Factor 2, the witness's degree of attention. This is where amount of alcohol has a significant impact on the analysis. She described herself as, quote, probably very drunk, and given the amount of alcohol she told law enforcement about consuming the entire day, that makes sense. She started with champagne mimosas in the morning, then White Claws 9 to 10 throughout the day. Then that night before she got home, she was involved in a drinking game and drank Borg, which is hard alcohol and flavoring. Her degree of attention, given this, supports unreliability. Factor 3, the accuracy of the description. Her description is that she saw a person wearing all black, not insanely tall. She doesn't know if she saw lips and nose. She is certain he is white. She never mentions eyebrows herself initially. The person who asked about eyebrows was law enforcement. In her second interview, Detective Mowry asked her if she saw the eyes, saw eyebrows. She never said anything about bushy eyebrows. Then in her third interview with Detective Gooch, she said she didn't know what the eyes looked like or the color of the eyebrows. That's for the first time that she mentioned bushy eyebrows. This lack of accuracy supports unreliability. Factor 4, what is the level of certainty of the witness? In each of the 5 interviews, she says over and over again, she doesn't know if anything she says is accurate because she felt like she was in a dream state, frozen shock, fuzzy and cloudy, like wearing blurry glasses, influenced by alcohol, and sleepy. She has an absolute lack of certainty. This supports unreliability. Factor 5, the science of memory looks to confabulation. When the acquisition of memory, the first factor that I talked about is impacted by emotion and stress. In this case, that is an important consideration. Confabulation is defined as the creation or substitution of false memories through later suggestions that fill in the gaps of missing memory. DM expresses in each interview how she was afraid and did not know what she was hearing, and also contradicts this when she thought everything was, quote, okay, and XK was simply just passed out on the floor. Later suggestion under this definition of confabulation is Detective Mowry asking her about eyebrows and each law enforcement officer, then reinforcing that in each interview. She never used the word balaclava, yet Detective Gooch asked her if she had ever heard of one, explained what one was and that it's used to hide identity, showed her a picture of one, and then had her draw one. This is law enforcement filling in the gaps. This also impacts the last factor, which is factor 6, post-event misinformation effect impacting retained information, exposure to subsequent information. Law enforcement, upon initial appearance at the scene, did not ever break up all of the people that were there. They then go to the police station, and after that, on the night of November 13th, those that were at the house when law enforcement arrived stayed together in a hotel room. So the DM was basically together with other witnesses from the time that when they first called friends to come to the house, before they called law enforcement, all the way through the night. She was interviewed twice by law enforcement. That created this exposure to bushy eyebrows. And then that term was used in the probable cause affidavit, and the media seized upon it from the very beginning, causing post-event exposure, which affects how DM's memory is retained. This factor supports unreliability. When you look at all of these factors, or the totality of the circumstances, the way the state argues it, the linchpin, the reliability is not there. The state wants to bolster a person who admittedly has no clear memory with a photo of Mr. Kohberger to say, this is the person she identified. DM told police that she looked at Mr. Kohberger's arrest picture and did not recognize him. The state cannot run around her unreliability by entering into evidence a photo to show it's a person that she says she cannot identify, because the state's interpretation is that Mr. Kohberger's photo shows bushy eyebrows. That is misleading to the jury. It will confuse the jury. It will be putting words into the mouth of DM that do not exist. While they might not seek to do that on the stand with her by admitting a photo through her testimony off of his phone, if they make the argument in an opening statement that that description of bushy eyebrows is supported by a photo taken on his phone the next day, that kind of prejudice is beyond repair. The state also claims that because DM draws pictures of eyes and eyebrows, she is more reliable in her identification of them. But that is not the way law enforcement appeared to have viewed the artwork as they photographed it and reported on it. Given the science of memory and its acquisition, retention, and retrieval, this could be what is filling in her memory gaps as opposed to actual memory. When you apply the critical factors that a court must take into consideration for eyewitness testimony regarding identification, the words bushy eyebrows should be excluded. The heart of the issue is whether or not the witness is reliable enough on the issue to let the words be spoken to the jury when it comes to the description. DM said that she could not do a composite sketch because she doesn't think she saw a face. The court should enter an order excluding the words. Thank you.
The defendant relies on the Manson-Biggers test. We just went through the 5-factor balancing test for their argument. However, that test is completely inapplicable in this case. Manson-Biggers has to do when there's a law enforcement-led identification process. The concern is that through suggestive techniques by law enforcement, it could lead to or create a misidentification. Well, that didn't happen in this case because it couldn't happen in this case. The male DM saw that night was covered head to toe. The only thing that was uncovered was a portion of his face. That does not lend itself to positively identifying any particular person. Therefore, an identification procedure was not used, and that Manson-Biggers test is inapplicable. Instead, on 4 separate occasions before Bryan Kohberger was even identified or arrested, DM gave consistent descriptions of the male she saw in the residence that night at around 4 a.m. Every time she described this person as being white, male, wearing all black, a few inches taller than her, she's 5'10", wearing a mask, skinny, athletic, tone, build, and not a voice that she recognized. During 3 of those interviews, she then describes the male's eyebrows, and she describes them as being bushy. Obviously, there was some focus on the eyes or the eyebrows by investigators because this is the only portion that she could see. She never wavers in her description of the person that she saw. She's very clear about what she does remember and what she doesn't remember. Defense put the state of Mr. Kohberger's eyebrows into question. In an attempt to discredit DM's testimony or description, they wrote, Mr. Kohberger does not have bushy eyebrows, but the artwork on DM's walls and the way she draws eyes and eyebrows could be described as bushy, full, or prominent. So in response, the state attached a picture of Mr. Kohberger, and obviously that's a jury question, but it was taken only hours after the homicide, so the closest in time to when DM would have seen the smell. And we did this in order to, when we did apply the Manson-Biggers test, to show that it turned out to be accurate. Corroboration does not equal prejudice. The state doesn't intend to introduce, they're correct. We would not introduce that photograph through DM. We would attempt to introduce that photograph and plan on laying the proper foundation and relevancy at trial. There's no grounds to exclude this testimony. DM's the only living individual who saw the person responsible for these 4 homicides. Her description of the male, including any characteristics such as bushy eyebrows, is relevant to the identity of the killer. It is prejudicial, but it's not unfair. A jury should hear this evidence, and the state asks that the court rule accordingly. Thank you.
I'll be brief, but I want to circle back to where I started. To say that there's no grounds to exclude this testimony is completely inaccurate because, in fact, there is a large body of case law and a large body of science about how important this testimony is. And that's why this court must analyze the reliability going through all of the factors that I expressed. And there is not certainty with DM in what she saw. And the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
Thank you. I'll take that issue under advisement. Text message, pardon me, 911 call.
Judge, the state seeks a pretrial ruling that the audio recording of the 911 call and a transcript of that call are an exception to the rule against hearsay. The state submits that the entire 911 call should be admitted pursuant to IRE 8032 as an excited utterance. At 11:49 a.m., BF calls her friend and to come over and check the residence. The friend and a boyfriend show up to the residence. At 11:56 a.m., BF places a call to 911. Just 7 minutes later, this 911 call was immediately after learning that HJ had something was definitely wrong within the residence, and his instruction that the girl should call 911. The statements were before the declarants knew their friends had been murdered the night before. The requirements of IRE 8032 are met, as this was obviously a startling event, and 2, the statements were made under the stress and excitement that it caused, and that's clear by listening to that audio. The defendant has proposed that their version of the 911 transcript be used, and the state has no objection to that. And I do have a copy of that transcript and the defendant's transcript if the court would like it. Thank you.
Well, I may ask you some more questions because it seemed to me from the briefs that the defense focused in on three particular parts of the 911 call as not falling within the exceptions. So you didn't address those specifically, but let me see where the defense is at.
Your Honor, the best place for me to start is to probably provide you with some copies of the exhibits that we're going to want to talk about. The first set I'm going to hand you was actually filed with the text messages. It's an affidavit of Josiah Roloff, and also, let me give you the extra copy. It has DM's messages broken out in bubble form. That's not all. I gave a whole separate copy for Giovanna. I think that's what I'm supposed to do.
This, to be clear, when we're talking about 911, but you're giving me text stuff.
We are, in our response to the state's motion about the 911 call, we referenced the whole copy of text messages. We just filed them with text messages, but they're appropriate here too for the court to consider. I have the additional exhibits that were attached to our response, and they are 1 and 1A. 2 copies. With those in possession of the court, I'll talk about the state's request. The 911 call is made 8 hours after whatever happened in that house happened, after the killings happened, according to the state's theory of the case anyway. The state wants to play for the jury the 911 call and give them a transcript of the 911 call as an excited utterance or a present sense impression. The context of all of what happened that night is captured in DM's text messaging. There's a separate text messaging exhibit for BF. But it's not that all of a sudden at 4 a.m. something starts to happen and then the 8 hours pass and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. And he really doesn't say a whole lot. The other statements that the state wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went in, went to the top of the stairs and went back out, and she saw nothing. She never went back inside that house. Any statement attributed to her cannot be an excited utterance. She's repeating what other people have told her. Similarly, If you look at the grand jury transcript, this is 1A, this relates to DM, and I'm at page 187, lines 12 through 16. DM is not responding to any of the statements she makes on the 911 call to a startling event. She says that for a brief second, she saw XK, but thought she was passed out from the night before. She also wants to talk about what she saw at 4 a.m, and the dispatcher stops her. Looking at page 190 of that same 1A transcript, DM talks a little bit about that morning when she woke up after whatever happened in the middle of the night happened inside that house, that she reviewed the text messages between her and BF from the night before. She was busy from about 9 o'clock in the morning on her phone. She was on Instagram, she was on Snapchat, she was on Indeed, she was editing pictures sometime in the night as well. This is not somebody who was asleep and then woke up and was startled. She is actively reviewing things that happened on her phone and communicating with other people. Any statements she made on the 911 call is not the result of a present sense impression. It's not the result of an excited utterance. It is somebody who's been awake and thinking about whatever she and BF talked about the night before and communicating with a lot of other people before that 911 call is made. The court should not admit the 911 call as an excited utterance, and the court should not admit the transcript for the same reason. But if the court chooses to admit one, having both is cumulative. So it would ask the court to exclude the 911 call.
Judge, I think there's a misapplication of the rule as well as the event that is causing the startling event, or the reason that they're startled. State agrees that this is somewhat of a culmination. There was definitely a startling event around 4 a.m. when DM opened her door and sees an unknown person in black in the house. She's not sure what to make of that, but that's obviously a startling event, enough so that she runs downstairs to her friend's bedroom. Yes, a period of time elapses. She wakes up the next morning. The next startling event is the fact that when she wakes up the next morning, her friends, she can't hear them. And she's texting them, and that's what her phone records show. She's texting them, giving them time to respond, and they're not responding. So at this point, she decides to call over friends to come and check on the residents, remembering what happened the night before. Now adding to that, that she's not hearing the roommates above like she normally would, and they're not responding in the morning like they normally would. Then she calls her friend to come over. Then the friend comes over, discovers Santa, and then instructs them something is wrong. And to the point that they need to call 911. That's truly the startling event here, is the confirmation that all of these things are coming together and that there's an emergency in the house that law enforcement needs to respond to, which is the context of how all of these statements are made.
What do I do, or what's your response to it seems like some of this I need to take bit by bit. And so, for example, EA stating that one of our roommates or one of the roommates passed out and was drunk last night. She's not waking up. She didn't witness anything.
Well, I think that falls under her present sense impression of what is happening at that time.
Her hearsay statement of what somebody else told her,
That's
she's
true.
not experiencing anything in that sense other than being there. And I think the case of my note here of Bemis is instructive.
Well, I would also argue that for this particular statement, we wouldn't be relying on it for that truth. So therefore, it's just not hearsay. Well, solely just for the context of the entire 911 call, but we wouldn't be asserting that what she was saying is true, that the roommate is passed out and she's not waking up. That's not the purpose, or that my friend's telling me that she saw someone in the house last night.
I mean, it's not offered for the truth. You better have a good answer about what the reason is other than the truth. And I'm not hearing one.
Only that it's part of the substance of the entire 911 call, and that part could be redacted, which still, that doesn't mean that the entire call should be redacted.
That's why I'm addressing them individually. I mean, there may be parts that qualify and there may be parts that don't.
I still argue that the entire call in its entirety.
Well, so here's kind of the way that shakes out. If you offer the tape, you, as an initial matter, can't put in stuff that is hearsay. It's unaccepted hearsay. If they want to put in the context, if it falls under the completion doctrine, they can. If it's the other way around, in the defense first plays the tape and parts are hearsay are left out and you want to complete it, you can. But you don't get to complete with hearsay your own offered conversation, or I think it applies outside the federal context to recordings and testimony.
Yes, that makes sense to me.
So when you say for the whole context, that sounds like the completion doctrine, which I'm not sure you get to rely upon. Well, I know you don't get to rely upon. And so when you say it's not offered for the truth, I'm not hearing something other than the completion doctrine that you're telling me about.
I think that's fair. I mean, we only have certain exceptions to the rule. If it, I still believe that the entire call in its entirety and under the circumstances that the call was made, the entire call could be considered an excited utterances by all declarants.
Also, there's a statement by EAO, and they saw some man in their house last night. Yeah. That seems to me to even be more removed. Again, it's a statement of a hearsay of somebody else. So you got hearsay within hearsay, and not by somebody who observed that and relating to the event that happened previously.
Sure.
So what non-truth purposes is that statement?
Again, I would just have to say that the whole
Because
cause of
that seems
excited.
to me to be even more concerning,
Right.
right? The first one, I mean, my roommates aren't waking up, and we're going to have that confirmed through other evidence. The statement hearsay that the roommate saw somebody is perhaps more of a piece of contested evidence.
Agreed. I still.
Concern about being an offer for the truth is even greater there.
Right, and the appropriate remedy, when there's not any grounds for relevancy for this, would be to solely redact those portions of the 911 call, not to exclude the entire call. And based off of the nature of the call and the fact that the phone is passed around multiple times, and it's hard to determine who's speaking at what times. And obviously a lot of emotion in their voice, considering what's going on. It's not always clear to understand what's being said. So I think a transcript is a fair way also to convey this, and should be allowed with the audio. Nothing further from the state.
Transcript and testimony. In other words, you're essentially admitting the evidence of somebody who transcribed it to say this is what they said. So to me, there's two different questions. One, should the 911 call come in? And second, should I allow, if there is a disagreement, a transcript?
Well, the state has offered to allow the defendant's transcript that they had certified.
The fact that certified doesn't make it otherwise independently admissible. It's hearsay. The transcript part of it.
Well, it's a transcript of the 911 call. I believe that it could be self-authenticating. It has sufficient standards of reliability built into the transcript.
That may be one. 24 might be a hook. You haven't complied with the requirements of 24 at this point, but
No, but we haven't met our exhibit or witness deadline yet. So obviously, we would have to lay the proper foundation for that and would intend to do so. Thank you.
right, I think I need to take a statement by statement approach to this. I do think that the surviving roommates, surviving victims of the burglary were under the stress of the immediate events. But there are some questions about some of the other statements in there as to whether they would come in. So I think in general, much of the 911 tape meets the qualifications, but not all of it. I think there are concerns with some of them, as I've outlined in my questions. But I will write that because to give you more particular guidance. All right, the text messages and testimony.
Thank you, Your Honor. Similar motion by the state asking to bring in the phone records for DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to come in. I broke those down in my motion and reply and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay. It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that BF responds, I think all of those are allowable under the excited utterance, as well as the present sense impression exceptions to the rule against hearsay. If you have any questions about any specific messages.
Well, Your Honor has our exhibits already related to this, and then in the record were BF's phone activity. I don't need to quote extensively from those. There's a lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit. I understand from the court's previous statement that the court would accept a complete copy of something versus just pieces of it. Well, I could offer
Qualifies for
it.
the completion document. If it's necessary to explain the prior admitted stuff and it's close enough connection in time and in subject matter. And so there's some questions there. It's not just automatic.
We certainly would understand that we'd have to present some information or cross-examine witnesses about that. The additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people. And it's hard to tell what it is because there's telephone calls and those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging. And the whole is what matters here and takes it away from being excited utterances because of the other activities of the two
Well,
people.
the activities that occur after. So for example, the texts between, at 4:18 or 4:20 or whatever, those aren't affected by the later activities of, surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies because my experience with that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing, right? And so understanding how they're using those apps is also important.
It is important, and I would refer the court to our affidavit from Mr. Roloff, talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone, and those are things that were going on, as well as editing pictures. The picture editing happened in those overnight hours. Instagram happened later in that morning.
Wouldn't affect the excited utterance and present sense impression of the earlier 4:00 text, I guess is my point, because those are afterwards. Those are after they retreated to the room together and, and what happened there.
Mostly, I agree. There were things that happened right before DM created a new contact at 3:51 in the morning.
Right, before
There-
anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
The foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous. And there is a break for BF, but it starts again right away. So I understand the court's looking at an isolated part of time, but I think it's important to understand what activity was happening leading up to that and what activity happened immediately after that when the two of them are together downstairs, to put it into context. One of the other concerns is the use of this text messaging, not just through the witness that's testifying, but to bolster each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning, the one's continuous, but right after.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion? Right? So, is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means an out-of-court statement. Then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance. And then we look at the surrounding events. Is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that, 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.
All right. Next item is the demonstrative evidence.
Thank you, Your Honor. In our motion regarding demonstrative evidence, we were talking specifically about, for lack of a better phrase, a dollhouse, a not-to-scale construction, a 3D model of the residence itself. And as the court can see from the materials that have been submitted, the configuration of this house is unusual at best. Certainly, we can use diagrams and floor plans, which we did at the grand jury. But it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out, what is on each floor, where the bedrooms are, how the first
Well, for
floors.
it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. And the concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed, and where everything was located. So it's not intended as a standalone exhibit that has significance. It's only a tool for the witnesses, not just the roommates, but the responding officers, the officers who investigated the crime scene, to point out to the jury where in this 3-story structure certain things were that they observed. And so that is our intent on this. We initially contemplated offering a 2-scale model, and the defense, I think rightfully so, said, okay, well, give us the background information and data that would be relied on. And we requested that, and for whatever reasons, we didn't get it quickly. But as we revisited, we realized that to scale maybe is not what we want. We just want a demonstrative exhibit that witnesses can use, much the same as a sketch, or if they would take a flip pad and try to draw things to help illustrate their testimony to the jury. So that's where we ended up here. We look at the balancing test under 403 as far as relevance. We believe this will be helpful to witnesses in explaining to the jury and to the jury in understanding witnesses' testimony. As far as prejudicial effect, the state doesn't perceive any significant prejudicial effect. Now, I realize that the expert witness for the defendant talks about jurors misinterpreting angles of view and stuff. Well, that would be true if we were dealing with a 2-scale exhibit, and the defense is welcome to offer their 3D imaging or whatever it is that they want to, if they want to have a 2-scale presentation. That's not our intent, though. Our intent is just simply to have this as a tool to help witnesses explain their testimony and help the jury understand.
And I think you understand this, but so that, it's clear. If it allowed as a demonstrative exhibit, it's not an exhibit in the sense that it goes to the jury when they deliberate. It will not go back.
Yes, we completely understand that. We intend this to be something in the courtroom that is physical, that the jury can look at and the witness can look at and point to things so the jurors have the most complete understanding of what their testimony is.
I haven't seen it, so I don't know how visible it will be to, you've seen now where we're going to be, how visible it's going to be to the jury from where it would be presented. So I guess if I allow, we'll have to cross that bridge.
And that's understood. The last communication we had earlier this week, Your Honor, from the folks at the FBI is that it might be finished within the next 10 days. I'll be candid. I had proposed to the FBI, let us get this in front of the court and get a preliminary ruling from the court before you spend the effort to construct it, but they went ahead and started anyway. So that's neither here nor there. It is intended, as you can see from State's Exhibit 1 or S1 with the dimensions in there. It's a fairly significant size, 35 by 48 by 52 inches. So the idea of making it big enough so the jurors can see it's out in the floor in the well, and they can actually see how things are constructed and arranged. It can take apart floor by floor so they can see each floor individually and then how they are stacked back together. So that's the purpose, to assist witnesses in explaining their testimony and assist jurors in understanding the testimony.
Your Honor, we request that you exclude the state from using this dollhouse model. As is everything we're talking about here today, we're talking about Mr. Kohberger's constitutional rights, and we're talking about the rules of evidence. In this case, though, Your Honor, this goes beyond that. This is something that came up in 2023, the fall of 2023. We were disclosed that a group was going to the house before it was torn down to construct a model. We promptly asked in discovery to receive information about this model so that we could start to understand it, so that we could work with our expert with it. And it wasn't until 2025 that we get more information about this. I don't think that calling it a demonstrative exhibit excuses what the state has done here. The state said they didn't have any of the materials. They didn't come forth with them. Their date to be done with discovery came and went. Their date for their expert disclosures in December came and went.
Demonstrative exhibits in trials are typically not brought to light in terms of being shown until oftentimes during trial itself. I mean, it's no different in some senses, as I'm hearing the argument, of sketching on a diagram on a pad.
It's completely different than sketching a diagram on the pad, Your Honor. This, if somebody's drawing something in open court, I can see them. Mr. Kohberger's confrontation rights about how that's drawn exist right then and there if they're drawing something on the board. This is an exhibit that's constructed outside. It's done in preparation for court. There were experts that took the 3D imaging to make this. There were photographs that were taken to make this. There's a process to construct this, and to take it from to scale, which might have made some sense because things would be there where they're supposed to be. And by things, I mean walls, I mean doorways, I mean angles of hallways, I mean lines of sight. Those things would be there where they were supposed to be if we were doing this to scale. But to not do that and call it a demonstrative exhibit so they don't have to tell us about it is really misleading to the jury. And there's a lot of danger for the jury to be completely confused by that. I don't think this change excuses what the state did to sit on this information and wait until the last minute when we don't have any ability to investigate it or to look at it.
You had access to the house, right?
No. What, to the old house? Yes, but not to what they're doing now.
But you had the ability to create your own models, to do your own measurements, to come to an understanding of the layout.
Absolutely, we did. What we don't have the ability to do now is to test the state's model before it gets in front of a jury, before different witnesses use the state's model to say, this is where I was and this is what I could see. If a doorway is just off, the line of sight is just off. That can be completely misleading to the jury. This is an unfair surprise to Mr. Kohberger. To have this come in and have the jury look at this, it's not a PowerPoint. It's not a drawing on the board. This is going to be this big 3D model that's going to be pushed around the courtroom. It's going to draw the jurors' attention. They're going to put a lot of emphasis on it. A demonstrative exhibit that may or may not be accurate, that may have the walls and the lines in the right place or the wrong place, that won't have depictions of furniture or the way the house really existed that night. And the jury can place great weight on that. And it might not be actual. It could skew the testimony. It could skew the truth. And that's really important in this case.
Where cross-examination comes in?
Your Honor, how can I cross-examine a 3D model that's constructed outside of a way I know anything about?
Well, you had access to the house and you know what the house looked like and you have photographs.
I do have those things, but if there's a slight shift in this 3D model, it's going to be more difficult to depict that. And that's a lot of runs around to try to get our expert to take a look at this, to try to get our expert to pull the 3D picture that would show that this model's wrong, and to try to get the jury to want to listen to all of that, when the best and easiest thing for the court to do is just exclude it. This is not a model that will do anything but cause the jury to speculate. It could easily produce testimony that's not true. The jury might be relying on things, and likely will be relying on things that are not true. When you look at the case law that talks about demonstrative exhibits, you're looking at things like PowerPoints. You're looking at, that's in the Weigel case, whether or not the demonstrative exhibit should go back to the jury. When you're looking at the Masters case, it's an exact car seat. That was a civil case. It's an exact car seat, like was in the case at bar at that time. Here, this demonstrative exhibit that's going to be large may or may not be accurate. Conversely, I have the photographs, so does the state. I've been in the house, so is the state. There's 3D imaging that was taken by the state and by the defense. With all of the thousands of photographs and all of the people that have been through the house, there's no reason to take a chance on this exhibit that will be speculative and will confuse the jury. To allow this is allowing the state to ignore the discovery process. They're just slapping a new label on this model and saying it's not to scale, so we don't have to disclose anything to you. To allow them to rename this is a violation of Mr. Kohberger's constitutional rights to due process and a fair trial. This should absolutely not be allowed. Mr. Kohberger we have done everything we can to be apprised of what the state's going to do. And at the last minute to pull this out after we've asked in discovery for this and to label it a demonstrative exhibit, Your Honor, that just can't happen if Mr. Kohberger is to have a fair trial and if his due process rights are to be adhered to. We strongly object and ask the court to order this excluded.
The 3D, or in the, I don't know if it's LiDAR or what they use, the 3D information.
I'm sorry, Your Honor.
You have the laser information,
As of March 4th or 5th, I think that we did receive that. We sent that to our expert. He wrote a declaration in support of our objection to this, to let you know how long it would take him to do the work necessary to even measure this, and then he'd need an on-site visit for this. And if the court allows it, that's what we have to do. But the court should be well aware that when the state does these kinds of things. These things mean taking their time and throwing things out long after deadlines come. There's a ripple effect that happens. We have to work with our expert. The expert has to carve out time in his schedule. We have to take time to understand what's happened and figure out how to respond to it. We are very close to trial, and those deadlines are important for a reason. All of the stacking up of things like this at the last minute outside of the deadline set by the court and outside of the rules further prejudice Mr. Kohberger and his ability to have effective assistance of counsel at trial.
Your Honor, what Ms. Taylor is talking about might be true and applicable if we were offering a scale model. We made the decision not to. She complains about the timing of the underlying FBI data. Well, that request from her for that information related to a proposal for a scale model. And we provided it anyway because she had requested it. In our view, it has no bearing on whether the demonstrative exhibit is acceptable and appropriate. The allegations that we've tried to sit on this and bury this, that's just silly. That's not what happened. We provided the information we received. As soon as we received it, it was processed. I don't think that the defendant can point to anything to say otherwise than that. It's just simply a demonstrative 3D model to help the witnesses explain their testimony and help the jurors to understand the testimony. That's all we're asking for.
Thank you. I will give you a written decision on this soon, shortly, but there is a significant distinction between demonstrative trial exhibits or trial models, charts, things of that nature, and attempts to use things for evidentiary value in and of themselves. The more complex, it's not particularly different than a drawing by a witness or something of that. It's not uncommon to get these very close to trial. Defense counsel has had access to the house, could have done its own diagramming if it had wanted to. It has now the information on the, I'm just going to call it the laser or LiDAR modeling measurements, whatever that was done by the FBI. It's April. Trial is starts in August. I think there's plenty of time for the defense to respond to an item that is not actual evidence. It is simply part of testimony that will be forthcoming at trial, and will not go to the jury. Jury will not have it in its presence when it deliberates. I don't see, frankly, the concern with respect to the use of a model in a case like this. So I'm going to allow it. The state will make it available to the defense prior to the pretrial conference and sooner if it doesn't sound like it's complete yet, but as soon as it's done and certainly as quickly as possible. And like I say, it's not going to be allowed for evidentiary value. It will be a part of the testimony. Whoever testifies is going to have to testify that it helps explain their testimony and that it's consistent with their observations. That's subject to cross-examination by counsel. If there are problems with the model in terms of view lines and things of that nature that they were able to put together through their own visits, through their own studies, through their own opportunities, including through their experts if they want to. So. All right, next I have self-authentication of records and reliance on 803. I'm not sure we're ready to argue this because I don't think the state has complied with the obligations in order to rely on the self-authentication issue if they haven't provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah, Your Honor, we agree. That's probably an accurate statement, and a better time will be after the exhibit witness list is due, and then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a meet and confer over the exhibit lists to determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. I have anything, counsel?
No, Your Honor, I won't right now.
All right, let's talk about alibis. This is the state's motion in limine.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor's staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights. And they're certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because his phone was turned off. So the only person who can testify to an alibi if there is an alibi is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time, or a notable time, before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the ability, the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was. But that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration. Now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on in 4, whatever it was.
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there. so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, so as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well,
it's that,
why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness,
sir,
or the alibi instruction likely is not going to be given.
sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right. All right, let's talk about the AT&T stuff.
Here we go.
Thank you, Judge. This should be fairly simple. The state seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period. So the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window. So there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
The defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're
So
talking.
you're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
I have nothing further. Thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific.
I read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that.
That's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
So the 7 days that he's back home.
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
you would
which
agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified.
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from
You're,
people that
you're,
I've worked
you're giving
with.
You guys I don't want to see or hear anybody arguing with moderators in here. I'm not going to put up with it. You'll be bounced. That'll be the end of it. Thank you.
a state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were
records.
asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't, because they didn't know who he was.
You're correct. They didn't know who he was until I think about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my
Our
attention more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you,
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
he is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days. And he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and provided AT&T sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available, and I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that, and I'm not going to allow testimony about that. Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it. But you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you. All right. The vague and undisclosed expert testimony, I think in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts. And so I wanted to provide that to the
So
court.
I did see that. and read it.
Okay, good. Thank you. Let me get to my same page. I want to start though today with my presentation and my request with a little bit of history with this case. And as the other motions are, this motion, our motion for the court to exclude all of the state's experts as outlined in our exhibit is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
Well, to be fair, and in the way I handle these issues with Rule 16 in the criminal context, the rule is not particularly broad about what is required. And the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts to encourage sharing beyond that which is required, because I think it helps both sides. And I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better. And I think it creates just a more fulsome picture of things that way. And that's why I invited the state to supplement. And I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16. And so that is my guidepost.
Well, Your Honor, I believe Rule 16 references the Idaho Rules of Evidence. And I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, it's the State versus Marin case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in that the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have, this is how we're going to prove this case, and for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Kohberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We tried to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, agent balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance doesn't, the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
Allowed to give an opinion about those last 7 minutes?
I'm sorry.
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion, their expert to have an opinion.
You can't. And we're here asking you to limit what they can testify to by surprise once we get to jury trial. Agent Balance is worth further comment to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done. And to understand that he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage. And then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you though, while we're on the topic of that last 7 minutes, that it's more problematic.
That was part of the initial disclosure, correct?
The PowerPoint, I believe, was provided as the disclosure.
Did he testify for the grand jury?
No, nope. Officer Mowry, Detective Mowry testified before the grand jury. Agent Balance did not. So I don't have any of his testimony. But I want to tell you about the 7 minutes. And I want to tell you that those are problematic. When the phone's moving, when Bryan's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative.
That's just impeachment.
Well, it's actually exculpatory to Mr. Kohberger, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that, and I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony from your expert about that 7 minutes and impeaching him about, you didn't even look at the last 7 minutes. You missed that. And what could that mean? Couldn't it mean as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
well, I anticipate impeaching for the lack of diligence. Here's the fear though. I don't know what he's going to say about those 7 minutes. So I want to impeach him about that. I want to impeach him about a whole lot more too. But if I do, and he says, well, I did analyze it actually, I hope the court's order stands and he's not allowed to talk about it.
You have to be careful about what doors you open, but
I agree. And when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce a thing. They have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline, and they didn't go home from the January 23rd and 24th hearing when the court said your job's not done, I'm not going to allow things in that aren't disclosed. They didn't go home and say, we got to get this done now. They trickled things in bits at a time. And that is just not the way the system works. And that's in violation of Mr. Kohberger's rights. And we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position. And that's the way to bring it back and keep the burden at the table it should be, and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. We had a lot to say about that with Agent Balance.
Search warrant application include the analysis of the cell teller information.
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
That large, omnibus document that they used,
Oh, Exhibit 1 that was attached to all of them.
attributed to, if not the signatory, but the FBI CAS team.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he
My point is
dictated
that
it.
Were you on notice of what the state's version through the CAS team of what that data showed?
If I look at the affidavits, there are a few things, yes, that I would be on notice for. They're not attributed to Nick Balance, but there are a few things. Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it. And let me tell you what I
Talk
mean.
about the adversarial part. I also looked then in that case at what information you did have about what the state's case was. And so, it seemed to me that in general that cell analysis was part of that, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion, and now for the first time, I know he actually analyzed it. What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis, and then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
I recall the 47 said it was traveling southwest.
Well, that's what we say. That's what the
affidavit-
record
what the-
shows.
That's what the application said.
The application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time. Southwest of Pullman.
That's not when the phone stopped reporting.
I realize that, but it's not like they were representing that it was at 2:47, halfway to Moscow or traveling to Moscow. It said it was southwest of Pullman, which, as I understand, the 2:52, 54,
70.
7 minutes later, indicates it was traveling southwest of Pullman.
None of the search warrant affidavits have anything about 2:54. It was,
I understand that. My point is, the time was wrong, but the point that the direction of travel is the same.
there are paragraphs in the affidavit that talk about the phone traveling towards Moscow. There are slides in Agent Balance's PowerPoint that have an arrow, and that's not true.
Well, there is in the search warrant affidavit, I think as part of the PowerPoints, I don't remember the language it used, but basically the believed route of travel or something like that. In other words, their opinion of what the travel route was. And so that was disclosed, what that alleged travel route was.
Cell phone records would indicate something different than they said. So and I see what the court's doing. The court's saying, okay, you have this PowerPoint. What else were you on notice of? I'm on notice of things that the records contradict, the records being the AT&T records that we received from the state. And those records contradict those things in the affidavit. I'm also on notice.
Allow for supplementation of expert disclosures to correct errors, to provide new information, to make them fuller. I mean, the rules allow for that.
That's not what they've done.
Jan, that's what you're saying. That's what they haven't done.
That's not what they've done, Your Honor.
And
And
that's why I'm looking at what did they actually say beforehand, because I think part of it is a notice issue. to you?
Well, I'm on notice of things that the records don't support. I'm on notice of a PowerPoint that doesn't have any analysis or opinion in it. So those are the things that I'm on notice for with regard to Agent Balance testifying. So I'd ask the court to not allow him to testify beyond the December 18th very limited disclosure. We have the disclosures that still have some vague language in them. And we talked about this back in January, where it's imperative to not let people offer opinions based on this vague language that they can change their opinions. That happened a lot with lab people. There were some additional disclosures with lab people bringing in CODIS. That came in the
That's not an opinion. First of all, it is an explanation of why they didn't submit evidence to CODIS. I don't see that it's an opinion. That's just a statement of what the facts are.
Your Honor,
It's not expert testimony. That's, here's our policy. Here's when we submit stuff to CODIS and here's when we don't. And this has been raised as an issue. Why didn't this get sent to CODIS? And this is why. I don't see that as an expert disclosure issue. That's purely a factual issue.
the protocol allows the individual, a certain analyst, to make that decision. That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is, I don't really view that as that as expert testimony. That is simply the underlying factual happenings. It's like, you know, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. You know, in my expert opinion, I thought it'd be good to call this person. These were fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the sterile DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can.
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, you know, it was the DNA of Y person, right? Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to. With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation but not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify about other things. And as long as they're kept to those opinions, I think we're informed on most of those. Again, not going through everyone. I do want to talk about Dawson, though. Dawson was an expert that was disclosed in rebuttal, but there was nothing to rebut. He's an expert that talks about toxicology. And we are.
Didn't you produce an expert who said that that there wasn't it would have required two people to commit the crime?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That
Dawson
doesn't.
testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. in rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway. So this would seem to be contradictory with other testimony that they intend to put on. We are not contesting the intoxication level of any of the deceased.
I understand your argument.
Thank you. Again, Your Honor, I think that our exhibit stands on its own, and I just wanted to highlight a few of these. I do want to talk about the cell phone and third-party data, digital data disclosures. We have a little bit more in the way of opinion now, but not full opinion. And the state said that we didn't give them enough to rebut, and that's because we don't know what opinions their experts are going to come up with. They still haven't disclosed full opinions, and so we want to highlight that for the court.
What haven't they disclosed?
Well, in the Barnharts, they said they were going to talk about habit evidence. I don't know what that is. Most of the rest, there were 3, Mowry, Urig, and Tanzola, that looked at the digital data and the cell phone data. I don't have any idea what they're going to talk about, except Urig is going to say that there's no connection between Mr. Kohberger and the others. That's the only actual opinion that's been disclosed. And that the last one I wanted to highlight for the court is the Douglas, Special Agent Douglas's testimony. That seems to have shifted a bit from he's going to talk about bank records and debit purchases, and it's become bigger without any opinion. I don't know what his opinion about anything will be. That needs to be limited. I think he can come in and talk
Through the financial records and say, this shows a transaction with Mr. Kohberger's credit card to purchase a Amazon gift card, and that this Amazon gift card was used to purchase a knife.
if he can say all of those things. I think that his ability to talk about receiving the bank record and looking at it and saw a purchase history, I think that's fine. But to provide an opinion about what that means, that's not disclosed. Well, Your Honor, I don't want to wait to find out. I'm asking the court to.
My point is I'm not in a position to exclude their testimony because they haven't shown me that they're offering something beyond what they've disclosed.
Your Honor, I respectfully believe that the court is in a position to limit what hasn't been disclosed and would ask the court to do so. The state has had a lot of time to provide these disclosures to us, and what they've done is taken the advantage of having our disclosures and bit by bit giving them to us. This is challenging to prepare a case of this magnitude in any event, and to have things piecemealed out just delays our preparation time. And it's also in violation of the discovery rules. It's in violation of the court's order, and it violates Mr. Kohberger's rights to a fair trial, effective assistance of counsel, and due process. And it is within the court's realm to say, you're not going to do any more after this particular date. There's no opinion written down for certain people. It can't be offered now. And we think that's what the court should do. If we wait until we take it as it comes during trial, that's better than nothing, but it's very difficult to prepare, and it eats into what limited time we have to prepare, and it will waste a lot of jury time to have to take these things up again and again and again. The state knew what their duties were. They've done this for a long time, and they chose this course of action, and the court should limit what they can do and issue an order limiting their experts.
defendant makes a lot of assumptions about what has occurred. However, I can tell you the state didn't wait to see what the defendant was going to disclose first. That would be an incredibly risky game for us to play. And that's not what happened. We know what happened. As laid out in the state's response, the state filed our initial disclosures on December 18th, 2024, disclosing 25 experts for the guilt phase. And then at our last hearing on January 23rd, the court addressed this issue. And Your Honor stated and issued a word of caution, instructing the parties that the disclosure should cover over disclose. We should really go back to our experts, lay out, and you talked about the amount of work that this would take well in advance of trial to go through everything that they intend to testify to and put that into a disclosure. And that it doesn't go as far as the civil rules, but that you didn't want to have these issues coming up at trial. You were very clear in that you directed to the state that our work was not done. We took that to heart. You did not set a specific deadline, but instead instructed both the parties that supplements would be reasonably allowed. In response, we did immediately go back. We went back to all of our 25 experts and asked them to review their testimony. We had to have several meetings to discuss what their testimony was going to be, and they supplemented their disclosures. On March 3rd and March 14th, the state filed the supplemental expert disclosures. I submit to you that the state has complied with Rule 16. We have a continuing duty to supplement. The defendant has filed expert disclosures past their deadline. The state has allowed that. We are trying to be reasonable in this. And in fact, in that stipulation to allow them more time to disclose, we stated, it serves the interest of the parties and the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. That's where we're at, and that's what we're asking for. Thank you.
If we were talking about one expert of the states, that might make sense. We're talking about wholesale not complying with Rule 16 and with the rules of evidence regarding experts. When we realized that the state hadn't complied with the rule and provided us very little in the way of understanding how their experts would frame the issues in the case, we sought an extension to prevent the state from having our work first so that we could try to respond to what their expert disclosures were with our experts. That wasn't something that was given to us. That was denied, so we filed our expert reports. For us to have a couple of experts that came later when the state has done their job as they've done their job, that is really a hollow way to say they did it so we can too. The state did not comply with Rule 16 or with the court's order, and the court should limit what they're allowed to produce at trial.
All right, I'll take that matter under advisement. I did invite the parties to supplement. It takes time to supplement. I'll look through to see if there's any significant new additions. Well, first, I'll look to see if what is given is adequate. Secondly, if there's anything that was provided that wasn't shaping and as I've said, making more fulsome, making more whole, making more clear what opinions there are. The defense I know was given, and as I explained, the defense has the ability to supplement as well in response to the state's supplementation. Part of the reason the discovery order is as early as it is to the trial date in this case is because in my experience in cases of this, we have this problem always of ongoing, continual supplementation and disclosure, and so I wanted to accommodate that within the time frame, within the several weeks to months in advance of trial. And so I'll look at it and I'll get you an opinion. All right. Amazon click activity.
Judge, this issue really ties into what we've just been discussing, and I think is illustrative of the problem. So when motions in limine were due, we had notified the court that we didn't have expert disclosures on opinions on Shane Cox, who was going to be their Amazon expert, and Michael Douglas, who they had listed also as having information about Amazon. So when we raised the issue with the court about incomplete disclosures, like Ms. Taylor was talking about, we still didn't have those at the time that it was time to file a motion in limine. So our motions in limine. So the motion in limine related to Amazon Click and Amazon Records has to do with a lack of disclosure. When we filed the motion in limine on Amazon Records, we then got supplemental disclosures on Shane Cox and Agent Douglas, but not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
There might
talk.
be some rebuttal stuff in there based on your disclosures in terms of why the Amazon data, as I understand it, you're saying shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation than that. But the issue is that we had received this data, and without expert opinions to explain what the state intended to do with it, it left us in a spot of trying to figure that out.
How was it vague what they were trying to do with the Amazon records? It was pretty facially evident what the relevance of those
They're
were.
not facially evident, Judge. We have an Excel file that has a ton of names with metadata, and then we have what is known as an Amazon click packet that the state has produced, we think from Shane Cox, that has a sheet that talks about specific purchases that include the knife, include things like the gift card that you were just talking about, but without any context. And our hope was that with expert disclosures, we would understand, was there going to be testimony from them that somehow there was information on computer searches, specifically from computer examination, or the context of what metadata might explain about the click pay documents that they got. We now have some information because we have got an Amazon expert who has explained to us what we have and what we are missing. Obviously, the evidence is important to the state's case related to the Amazon information. And given the court's direction about its intention for us to call experts today, which Mr. Howell is available, we went ahead and submitted a declaration when the court said that you were disinclined to allow testimony, and we sought leave, but we didn't get a solid answer. So you've now got an affidavit in front of you, declaration.
Typically in motions in limine, I'm not being in a position to make factual credibility findings and the like. And so the testimony on paper is more than adequate to guide the court.
Okay, I appreciate that. So I'm going to explain then what the basis is for where we're at. The other issue that of course the court knows is that we sought to seek suppression of the Amazon records because the warrants were extremely broad. We expected to be getting significant data or have data that we hadn't yet reviewed. The court denied that suppression issue. And so what we know that we have now is the list that I explained, but it's without metadata. And so for the purposes of what we've got going on here, there is, pursuant to Rule 106, a whole level of context that's really important to the Amazon data. And it's not just AI technology, it has to do with machine learning. And I think a lot of this is something that
AI.
pardon?
Isn't that AI machine learning?
I think that machine learning, I'm definitely not an expert on this, Judge, but I've provided you with a declaration. And if you want me to put Mr. Howell on to testify about
That's
the
not
difference
important.
between, he's far more articulate at it than I am. It's a combination of both with what happens with Amazon, because in terms of machine learning, one component is that when there's a household account where there's multiple users with multiple cell phones and multiple laptops going into purchases, there's machine learning and cross references there. In terms of the way that Amazon works as a company globally and artificial intelligence, they're doing all kinds of things to understand what consumers and purchasers and sellers are trying to do to actually prompt people to buy certain things. So in this instance, with regard to these purchases, we have very limited data regarding Mr. Kohberger's purchases without the metadata and the context. And that's the reason that we are seeking to exclude it. Now,
Well, you got what they got, right?
Not really, because what we have is, we know that they're going to draw conclusions and that they're going to draw conclusions about intent, but the way that they've presented it to us in data is that this relates to Amazon clicks. Well, Amazon clicks makes it sound like to me and you, someone goes on and actually, with a mouse, clicks, opens a document, takes it into a cart, purchase it, and it's a much broader term than that.
And the state's testimony from their person who will testify that this is what the Amazon data shows, is that Amazon data shows that Mr. Kohberger, or at least his name, purchased the knife sheath and cleaning thing, knife sharpening, equipment. And looked as anybody who orders on Amazon does, where's it at in delivery? And then later on that same account, after the homicides, looked at knives again. Now, I understand the defense's position and evidence and expert to be that, well, that's a shared account and anybody could have done that on that shared account. I don't know that that's a matter of exclusion, though. Isn't that a matter of just impeachment and cross-examination and your own experts?
That if the court doesn't exclude it, then that would be the remedy and the approach that we would
Would it ever
take.
be the remedy of exclusion?
Judge, if you don't exclude it, then that would be the alternative, I
What
guess.
basis would I have to exclude it?
I started with that we did not have expert opinions at the time when we had to file a motion in limine regarding this data. And it's misleading that the way that you just portray it, that because there is a purchase in a household account, that is automatically attributable to him, and that there's
It's more than
somehow
a purchase in a
intent.
household account. It's attributable under his particular name in the account, as I understand it. Now, could somebody else in the family get to it? I don't know. I suppose your expert will tell us that. But I'm not sure how that is excluded, and I'm not sure how that's expert testimony. I understand you have an expert to say, well, all these other factors come into play and all these other things could have happened, and okay, you can put that on, but I'm not sure why that excludes the state's evidence.
Well, it would be extremely misleading, given the declaration that we've put before the court about everything that goes into the way that Amazon
You're
functions.
asking me to be the fact finder again. I mean,
I'm not asking you to be the fact finder. I'm telling you that when we don't have complete disclosures and we're playing a guessing game of what this information means, and we have deadlines where we have to file motions, then we end up in this circular situation right now, right? Because we had to file a motion about this without knowing what the opinions are and what we're lacking in data. Now I have an expert who's explaining it. We've asked you to exclude it. You're indicating you don't think it's an expert opinion. And so then the next logical step would be our expert comes in and we're allowed to confront the evidence. But you also just proffered that, that based on the information that you understand, that equates to a purchase. And I've put a declaration in front of you from an expert that says that Amazon doesn't work exactly that way. And that's the problem, that when it is represented as a click, that indicates to the average person that he sat at a desk and clicked and made a purchase, when there's a lot more to that.
and maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
That is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works, right? And so the state wants to apply in an argument. They will apply intent to purchase a K-bar to get to November
It's an
13th,
inference that you can draw from
2022.
the evidence to argue at closing arguments.
But we still have to have testimony that explains those things in between.
Welcome to put on testimony that implies that Mr. Kohberger was not the one that hit purchase, or that he purchased it for a benign event, or that here's the knife, I have it. I don't know.
And based on what you're saying, that the Mr. Cox you think is a lay witness, then I'm assuming that also extends to him not being able to testify beyond what the disclosure is as a lay witness, and no other opinions, and including Agent Douglas, who's given us no opinions whatsoever.
I don't know what they're going to say beyond that. And if they say something beyond that that is an expert opinion that hasn't been disclosed, then the state's going to have a problem with it.
Okay. That's why we're having these arguments, Judge. They take a lot of work. It takes a lot of energy. It keeps us from 68 terabytes of evidence.
Well,
If everybody would just disclose, we wouldn't be having this
but I
back
think
and forth,
the problem is you view it as a more complex issue than the state does.
because it is.
Well, that's not their worldview. Okay. And that's the factual dispute that the jury gets to decide.
So what we're trying to do is make sure that their myopic worldview is what they're held to, because there is a much bigger picture to this evidence. Okay.
Judge, this is pretty simple. Shane Cox and Mike Douglas, since he gets brought up, they're fact witnesses. They're not going to have opinions. They review records. They're going to testify to what those records show. Shane Cox's testimony is laid out in the supplemental amended disclosure. This is exactly what he's going to testify to. And what he's going to say, he's very careful in what he says that he's going to say. That's what we're anticipating. There is no grounds to exclude his testimony. We applied for and we were granted a search warrant for Bryan Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories. It directed law enforcement to see certain items: his customer click activity pertaining to knives and accessories, his payment methods used, details of items in cart, including all items added to the cart or removed from the cart or wish listed or in a shopping basket, all suggestions made to the account, all records regarding reviews by other Amazon users, advertising data, devices used to connect to the account, and all accounts linked to the account. The state requested the data between limited time periods, March 20th to March 30th, and November 1st to December 6th. Those were the relevant time periods. And in response, we got responsive data, and that's what we plan on presenting to the jury. Amazon's use of AI is not a basis to exclude, and it's completely irrelevant. AI doesn't click on things for a user. There are no legal grounds to exclude this. We ask that you deny their motion. Thank you.
Thank you. So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it? What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those or without a rebuttal disclosure to some of the things the defense has disclosed on that, they're not going to be allowed to testify to it. But there's not a ground for exclusion because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence. All right, let's take 10 minutes and then we'll see if we can't bring this home.
What a damn mess.
It's pretty sad, isn't it?
This is absolutely I want to fight this guy at this point. That's how frustrated I am.
Well, there's nothing changed since lunch. I mean,
No, it's
everything
just
this
gotten worse
morning-
in my opinion.
Yeah, it's consistent from this morning.
And now he doesn't let Massoff speak either. I mean, it's just any.
Think you're muted, Dago.
Can you hear me?
I can now. Yeah.
This just nuts. It's nuts.
I think the best answer that they've gotten so far is, I'll take it under consideration. And that is like one time out of half a dozen at best. And what that means is probably he's just going to seek counsel and see how they can defeat that argument.
Agreed.
So since lunch, we've discussed bushy eyebrows. I got no for that one. We've got dollhouse. I've got no for that one. Excited utterance, 911 call. I got no. Alibi, no. Timing advance / Siree, no. Undisclosed testimony, no. And Amazon, no.
Well, those ones in the beginning, he hasn't ruled on those ones at this point. He's made statements and changed it around. We'll see.
Well, these
But
are
for
my
the rest of
predictions.
those, you're right.
You can just read his body language.
Well, I mean, yeah, it seems that way, but I'm giving it the benefit of the doubt because of the way he sounded when he talked about it. We'll see. But I have a bad feeling that you're right. You're going to be right based on how he just keeps getting worse with everything. So,
Well, if he was sincere, and if this wasn't an upside down world, then there would be no need for the interruptions. He would listen. But anytime that he interrupts, you can just automatically mark it down as a no, because it's consistent with the court hearings for Franks back in January. That's how he conducted himself, and that's how his rulings went.
Yeah, agreed. We'll see. We'll see. Like I said, 90, I'll say 90, 90, 95%, 96%. You're absolutely right. Okay. I'm just going to give it the benefit of the doubt because you never know. But I'm already pretty much there. We'll see. We'll see. His
Yeah.
body language tells a story all by itself. You are absolutely correct. He's just sorry guys for my language at this, but he's just an asshole. Period. There's no two ways about it. He's very arrogant. He's very cocky. He's very sure of himself. So be it. So be it. And that's why I feel really bad, because at this point now, we heard what he said about the Cyree shit. I knew that was going to be that way.
That was bad. Glaring omission and conspiracy theorists.
Okay, so
the fact that he said that, Eddie, is a whole bad thing in itself.
Yeah, he's already made up his mind.
Right. That statement right there. Hold on, Hemisphere. I'm sorry, bud. That whole statement when he made the conspiracy theorist shit, I was done right there. That says absolutely right there what his thoughts are, in my opinion. So go ahead, bud.
I was just saying, y'all see the trial about Alec Baldwin? Right at the end, whenever she admitted that there was some bullets that was supposed to be on the scene or something, they didn't have it. Well, somebody came in with those exact bullets and backdoored them and gave to law enforcement. They did never. The defense never, or the prosecution never presented back to the defense. In the Alec Baldwin trial, I forgot what they called it, but she declared a mistrial.
Mm-hmm.
If they go to trial and do the Cyree thing in trial on the outside of the presence of the jury,
right,
as big time, and he even said it himself, right after he made that statement about it, that a lot of heads will be, I mean, you got people that's going to look like looking to lose their jobs. He even said that. But my question is, why do you want to wait till trial? Wouldn't that be something you want to do before trial? Because they don't want to have a mistrial. That's why. Because it's going to get thrown out. That jury is, there's no way they're going to convict your Bryan Kohberger.
Absolutely.
There's no way.
Well, I disagree. This won't get thrown out, and they will convict Bryan Kohberger. And this is how they're going to do it. We're witnessing the beginning of it right here.
It's not right. I feel bad for Kohberger, man. I really do. I feel bad for him.
Yeah, well.
So when it comes to Bryan Kohberger's alibi, he's going to be limited to just testify for himself on the stand about it if he chooses to do that, because
they don't want that, I don't believe, but
since Cyree, and again, this is my prediction, but that's his only recourse at this point.
Yeah, they're not given a choice. And it's sad. It is beyond. I could have never imagined anything like this in real life. You know what I mean? But it's happening as we speak.
Well, and you look at the Delphi case. I mean, there's an interrogation of him saying that he did not do that emphatically, and then later on, he admitted he did do it,
But he didn't, though. That's the
but
thing.
he did.
The when he admitted to that, it was under duress because he was feared for his family and himself. So that's where that admission of guilt came from. And that's a whole other situation that's absolutely disgusting. I can't even begin. I'm not even gonna touch on that right now. It's just disgusting.
I was just saying that, Diego, because it's screwy. You know, it's really, really screwy.
Well, let me say something. Let me ask you this, bud. If you get arrested and you know you didn't do something, okay, and they take you to prison, not jail, prison. They give you medication. You have no idea what it is, nor do you think you need it. But okay. They threaten your family. They're feeding you food. You have no idea what the hell's in it. They're threatening you on a daily basis, making you feel uncomfortable. And it's in turn to make things stop in your mind. Are you going to say, "Yep, you know what? I did this. I can't. I fear for my family mostly." The man had to ask every day, was his family okay? Every day. So at some point, I thought about that one time, and I was like, you know what? If I was scared to death that they were going to hurt my wife and my kids, yeah, I think I'd probably say I did it too, just for them to leave them alone. So that's where I believe that situation with Alan came from, in my opinion. They broke him down. You know what I mean?
Yeah.
As you've seen in the interrogation, he wasn't playing that shit. He wasn't in for that. You know what I mean? I'm just like, you're an asshole. I'm done with this. I see what you're doing. And that's not how this started, which we know how they do that. But now look where we are. So that's how that whole situation went down as far as I'm concerned. That's my opinion, of course. But anyway, I mean, we're not on that, but I see where you were going and what you were saying. But it's the same type situation. They're not giving Bryan any choices here. So,
And it's all what I got out of that, especially for Bill, was he never came up with an alibi, but other than driving around. Then he said, "Well, we know you was driving around." Well, wait a minute, hold up. I remember when he did come out with that, he was going to that park to look at the stars, but everybody didn't want to believe that.
WSU told the entire school that night. They announced it. There was something that they talked about via the area there about a meteor shower that was happening that night. Okay. So in turn, I'm sorry, but I think that's cool. And if I was a student there, guess where I would have been that night? Just saying. Not everybody's into that, but some people are. I think Bryan was kind of a nerd. I'm a little bit of a nerd. You know, if I hear there's a meteor shower or something I ain't never seen, I'm gonna go driving around looking for it.
I mean, who hasn't never watched Star Wars or geeked out on some Star Trek or something?
Right,
you know?
Right. So
looking through a telescope, you know.
Yes, exactly.
What you people that's outside of that realm, I can see. You know what? That's weird. But when you are a nerd like that and that's your interest, well, shoot, yeah.
I even honestly, dude, even somebody that's not really a nerd, if it's not something you've ever seen before and it's coming from space, let's go check it out. You know what I mean? So
yeah.
And that's just not enough because, well, we know why. But
I was into the Challenger thing, you know, back in '86. You know, I remember being in school, we're in class watching that stuff.
Yeah,
you know?
Yeah, I remember that.
Unfortunately, that happened to them people, but
exactly.
But you being weird like that does not mean that you are a murderer.
No, it doesn't at all. That's the whole point. That is a good point about him. I'm just saying. I mean, it was put out there via the school, and that's based on what we've been told. That's where the man was. That's enough for me. Sorry. Because I'll tell you one thing I do know for a fact. He wasn't at King Road. So there's that.
I have a quick question. The chat was talking about the date 16th of November. I think right
November.
about the time they were arguing the alibi.
When Ann said November 20th, they said November 16th, right?
Yeah, I didn't catch that. So just make a mental note of that. Maybe if you do a reaction live stream tomorrow or something, we can explore that further.
Yeah, I have it written down right here.
Okay. I thought that would be something noteworthy to re-listen to and check out.
Yeah, I might come in here tonight. I'm so pissed off right now, Eddie. I might come back, depending on what time they end this. I might come back in here because I'm so hot and pissed and just irritated with this guy. I did expect this, but not to this extent. I don't think.
What is he thinking about the Cyredo? That's huge.
Because he knows that, and the thing that he said was he doesn't have proof. He doesn't have that, but they do have Cy did give that name. I don't have it in front of me right now, but he did give a name of somebody, and they did basically state that there's proof of it. So allow him to demonstrate for you. I want to hear it. He should allow him to testify. Period.
Okay, so what is this 7 day stuff? What's that about? That's what he was saying. There's 7 days he wasn't talking about.
He said Cy disregarded it completely, which he didn't. If you read the document, I think it's bullshit too. The 7 day thing, but that's me.
He framed it as a glaring omission.
Yes. Yeah, it's a damn joke. So I think it was, if you go past this 7 day period of time, you can't get that information. I'm calling bullshit. Okay. First off, the FBI can do whatever the hell they want to do when they want to do it. This is a cell phone company. It's not like it's NASA or anything like that. And we've seen the FBI get things that they need to get when they want to. Okay. They absolutely can. So I don't take that. I'm blowing that off as bullshit. So absolute bullshit.
I mean, just the fact that he had that argument at the ready, he was just ready to use it too and throw it out there because this was prepared for. I always refer to this, idea of like a briefing.
Yeah.
All these decisions have already been made. Now it's just a finger drill, so to speak, to have this hearing and to listen to the argument. I mean, the ruling's already been made. So it's just more, to me, that's just more evidence of it. The fact that he's already got this thing ready to be thrown out there, calling it a glaring omission and using that as like,
he definitely had
reason
that
to disregard it.
He definitely had that statement ready. I promise you that. I know. I agree with you on that. Yes. Because he got excited about explaining it. You could see that. I just don't even know what to say, you guys. I don't. I'm very, very highly irritated with him. I think he's rude, unconscionable. He's just obnoxious to an extent. And he's just definitely shouldn't be handling a case like this, in my opinion.
Yeah, the fix is in.
What's that?
The fix. I call it the fix. The fix is in.
I got you.
That was the first thing that crossed my mind right after he's made that decision was who is his puppet master? Who is pulling his strings?
Well, here's another question. Why was it such a big deal? Why does he keep going around the fact that all she said she wanted to do was ask Nick Balance a question? Just one. And then she finally got it. He gave it to her, outside the jury. But still, she had to fight to get that. Everything they want to do, they got to fight to get to it. Shouldn't be that way. Sorry. He's got to argue it, everything, and frustrate them, get them all worked up too, because you can see it.
Yeah, I know. Cutting off the fan
and whether he wanted the case or not, whether he wants to be there or not, he is. It's your damn job. Deal with it, okay, and do the right thing. Because I promise you, this is definitely going to appeal an appellate court, and I pray to God that when it does, that it's seen for what it is.
Yes, it is going to an appeal.
Yeah, I have a bat, and I said this before, Eddie. You know this. I think he's going to get convicted. I'm
Yes.
almost positive at this point. I really do believe he will be, and then the appeal process will start. And I have a feeling that if everything goes right, that it'll be overturned within the appellate court. That's where I think it's going to come into play, and then all sorts of shit's going to hit the fan.
Pray for
And
it, because that'll take a miracle too.
Well, it is. I'm definitely, that's my hope and my thought, and we're back. And you're probably right, but we'll see. It's just insane. How many more motions did they have?
We are now at the state's motion regarding neuropsychological and psychiatric evidence, as well as then closely followed by the defense's motion with respect to autism spectrum disorder.
Thank you, Your Honor.
You gonna argue about that too, ass?
I hate to sound like a broken record, but once again, this seems to be a developing issue. The basis for our motion when we first filed it was in response to the defendant's supplemental responses on experts, the declarations of Dr. Orr and Dr. Ryan. Each of those talk about mental condition. And each of
Actually, Molly, I think she has to, based on what he said. So that should be coming too.
under 18-207. So our response was, well, then it's not admissible. It's just very simple. The statute covers that. What happened after that is that it morphed now into a new position from the defendant that there are neurobiological and physical conditions that are come into play. Not to the exclusion of the mental conditions that were alleged before, but Dr. Lewin talks about the physical conditions are predominant as opposed to exclusive. So that kind of brings us to where we are for the issues for today, and I'll try to be as succinct as I can. The first issue, what was initially raised by the defense, is they expressed concern about how the defendant's demeanor is going to present to the jury as the defendant is just sitting in the courtroom at counsel table like he is right now, and assert that they should be able to offer evidence that the defendant has autism and these other disorders that make him appear, I guess, arguably in like he's not involved or something in a negative fashion. The defendant cites no authority for this, and indeed, I'm not aware of any authority. We can't find any authority to say that the defense can come in and even before jury selection say, okay, ladies and gentlemen of the prospective jury, here's this expert testimony that our defendant has this developmental condition, this autism condition, and so he might appear different in court. And so please don't hold that against him. But there's just simply no basis for that. And we looked for that. It's irrelevant to any of the factual issues in this case. It's irrelevant to the elements of the offense. Frankly, all it does is confuse and try to play the sympathies of the jury, which is exactly what Rule 403 would prohibit. And we cited to the Schuler case where it talked about in the context of prosecutorial misconduct, it talked about the defendant's courtroom behavior off the witness stand is irrelevant. I think it stands for that. The defense argues that the Samuel case expands all of 18-207 to include mental conditions that don't directly relate to an element. And that's simply a misreading of the case. Samuel dealt only with subsection 4, which deals with the state's ability to right to request independent examinations. And the Supreme Court said that applies to any mental condition evidence the defendant opens up. It doesn't change the first sections of 207, which limit the defendant from presenting mental condition evidence.
What is going on? Come on. Can you guys
Somebody pull the plug.
Can you hear me still, guys?
I can hear you.
So it's their signal then.
I can hear you.
Can you hear me?
Yep, it's their signal then. Son of a bitch. You got to be kidding me. Is everybody else in chat still see and hear us okay? Yes, okay. Yeah, it's their signal then. Let me see. It says my signal's excellent. Okay. Damn. Are you guys kidding me? So now he's saying that basically, from what I'm gathering at this point until this comes back on, he's basically saying that that the autism's fake.
You
Is that how
try.
you, is that how
I'm
you're
sorry.
taking it?
I'm sorry, Dago. You can try refreshing it and see what happens.
From defendant's experts, particularly Dr. Orr,
There we go.
is she talks about the developmental disorder impacts being limited to in the past, page 16 of her declaration. She said the motor problems have not impacted his functioning significantly in many years, page 19. She said she observed the defendant manipulating items effectively during her evaluation, which would be contradictory to what the defendant argues, which is not in Dr. Lewin's report. The defendant argues that he's physically incapable of committing these crimes. To whatever extent that is irrelevant, we submit on the issue of guilt. It appears to us that what Dr. Lewin has to offer largely relates to the penalty phase. Indeed, he wasn't disclosed as an expert, and we aren't going to play hardball with these deadlines, but his disclosures came out as we were moving into the disclosure for penalty phase experts, not guilt phase experts. So the state's position is twofold here. First, we'd ask that the court enter order prohibiting the defendant from offering evidence about trying to explain the defendant's demeanor in court when he's not on the witness stand. It's irrelevant, it's immaterial, it's certainly prejudicial, it's going to confuse the jury, it invites appealing to the jury's sympathies. And then the second thing is we would ask on this issue of the motor skills that the court simply reserve a decision on that until the door is opened and we have specific things that the defendant's experts might wish to rebut, whether through experts or through cross-examination. So that's the state's position, Your Honor. Thank you.
Judge, the court should consider as an offer of proof on, as it relates to this issue, the initial expert report that was provided in the fact phase of Dr. Orr and Dr. Bryan, and Dr. Lewine's report was attached to our reply for the basis of substantiating that our argument is that this is a neurological, biological disability. We are not taking the position that this is a mental condition. Clearly in the state of Idaho, one of the guiding cases regarding mental condition.
Is there an inconsistency there? Because it seems like on the one hand, you're arguing that his autism spectrum condition shouldn't be used as an aggravator, as a mental health condition. I mean, yeah, it shouldn't be used as an aggravator, as a mental health condition. On the other hand, you're arguing is not a mental health condition under 207.
So I think that it's really important. I know that you group these two arguments together. This issue that I'm talking about right now has to do with the fact phase, the guilt phase of the trial. Everything related to aggravator is at a different phase.
Are you taking the position that it's a mental health condition as it relates to aggravation and not a mental health condition as it relates to guilt phase?
I don't think we've said anything about it being a mental condition as it falls under 18207. We're talking about this being a neurological, biological disability. My understanding, just so that we're really clear about what constitutes mental condition in court on a mental health condition, is the Diaz case, which is pretty extensive about what you're talking about. That's not what we're talking about here. We're talking about a neurological disability that has to do with his brain and is a biological condition. The reason that this is important in the fact phase, there are a couple of reasons. But as we talked about with earlier about the juries judging him, the minute he is sitting in a courtroom and the first time that a jury starts to look at him, they are going to be evaluating his physical presence. They will be judging his facial expressions, his posture, his movements, his interactions with counsel, his responses to evidence that is up on the screen, his responses to emotional testimony, and his eyes. The jury will be studying literally everything about him. We must, as his attorneys, be able to tell the jury in opening statement that he has autism spectrum disorder and that they will hear testimony that it is a neurological and physical condition or a developmental disorder. Studies show that jurors pass judgment on the physical presentation of the accused. One study in particular related to autism was in 2018 by Katie Morass, Imogene Marshall, and Chloe Sands. They did a mock jury study of 160 jurors, and half of the jurors were told about the accused autism spectrum disorder and the other half were not. And what the study found is that when the jurors understood what autism spectrum disorder was, they were inclined to be less judgmental regarding the physical presence of the accused. While first impressions of autistic adults are less favorable, studies like the one that I just referenced show that informing of observers of the ASD diagnosis results in significantly more favorable consideration. There are several cases for guidance to this court. State versus Spur, 921 AD 1335, a New Jersey court from 2007. The conviction was reversed and a new trial was ordered in a murder case. The court held the evidence would have educated the jury about oddities in behavior that defendant might exhibit in court or were described in the testimony of witnesses. The testimony is equally relevant to defendant's effort to have the jury understand any unusual demeanor or mannerisms he may have as a result of ASD and to explain his asserted shortcomings in perceiving and reacting to basic interpersonal cues when engaging in social interactions. He must be permitted the opportunity to present at trial evidence that tends to prove that he has a medical basis for such behaviors in order to explain himself and his condition and thereby to lessen the chance of being misunderstood by the jury. Another case out of Missouri, State versus Boyd, 2004. A Missouri case was reversed on appeal with the exclusion of expert testimony about autism. There were many similar issues as the case here, and it actually was also a stabbing case. The appellate court that the failure to allow expert testimony at trial had a prejudicial impact on the outcome of the trial. There were issues of clumsiness, awkwardness, and motor skills. Another example, State versus Suber, a 2008 Minnesota case. In an unpublished opinion, the Court of Appeals overturned a DUI conviction because the court, who conducted a bench trial, inappropriately weighed the evidence by ignoring expert testimony related to autism. Odd behavior and dexterity problems were at issue. Another case, a Ninth Circuit case, U.S. versus Cottrell, 2009, was not published in the West Federal Reporter. It's a California case. A conviction for aiding and abetting arson was overturned because the court excluded expert testimony related to autism on the issue of specific intent. The court held it was an abuse of discretion to exclude the evidence. There's also a brand new law review article out of the University of Alabama, March 4th, 2025, by Jenna Hayes, published, called Autism, Culpability, and Sentencing. It was just recently presented at the American Psychological Law Society conference, and it addresses many issues related to autism spectrum disorder in the criminal justice system with strong recommendations that expert testimony at trial is critical. The jury needs to know from the very outset that they will hear testimony about Mr. Kohberger's autism spectrum disorder generally, and how his physical presentation in the courtroom should be considered. For example, aside from his flat affect, piercing stare, stiffness, holding still, when emotional evidence or picture evidence comes in that a neurotypical person will react to, he will not react. And that is only because he has a physical disability that prevents a neurotypical reaction. It would be unfair for him to be judged for that given his disability, or at the very least, the jury needs to have some understanding of why that may be. As for issues that relate to state of mind, it does depend on what the state offers. We agree with the state on that aspect. If they stay away from the issues regarding cleanliness and a missing shower curtain and speed in which the crime occurred, and wearing gloves or showing him at various places wearing gloves with some sort of negative attribute that he is doing that to hide DNA as opposed to what's going on with his autism, it's our position that that opens up the door to the opinions that the experts have expressed. As it relates to
I didn't understand the reference to speed at which the crime occurred.
well, there's the state, there's a disclosure by the state
Right?
of one of their
I
detectives.
understand the detective's statements, and you have in the report a reference that he has a historic fine motor skill issue, and you have no expert testimony that he would have been incapable of doing this.
I don't know that we would seek to offer an opinion that took it that far into the jury province about no capability to do this, but in terms of his fine motor
All he
dexterity issues.
disclosed is a historic issue with some fine motor disabilities, like not being great at tying his shoes.
Well, I disagree that that's all that the expert said. The expert indicates he has problems with dyspraxia and went into great detail about the issues that what she saw with fine motor dexterity as it presents to this day. He did absolutely have those issues as a child, and there are still things that are present in him. And you know, to the extent that that's an issue, the best person to explain that to you is not me, but perhaps a more of an offer of proof beyond this outside of the presence of the jury. So what you would know, the testimony would be that we would offer on that issue, or giving us direction to specifically go get information about that issue that we might try to elicit. But I don't want my representation to you as a non-expert, as a lawyer making this argument. I'm not qualified to tell you what's going on with his exact dexterity issues. He has fine motor skill issues. He presents odd physically, and it is a different presentation with what he's got than someone who might be sitting in a courtroom, perhaps with missing a hand, for example. Another significant issue that is impacted by his ASD is his decision and ability to testify. The Burr case is instructive because part of the basis for the reversal was that Mr. Burr was encouraged not to testify out of fear of how his autism would come across to the jury. Because of his ASD, because of Mr. Kohberger's ASD, decision-making is already very difficult for him. If we cannot let the jury know about Mr. Kohberger's autism, the decision about his testifying will be nearly impossible for him and for us as we guide him. We need to avoid misperceptions of the jurors. And the only way to do that is to inform them. The cases I have referenced discuss how the constitutional right to due process is violated when a jury does not get to take into consideration this specific type of evidence. There's one other way that I want you to think about this, one other frame of mind. Imagine if you do not let this testimony in phase 1 of the trial, and the jury convicts Mr. Kohberger. How angry and misled might those jurors feel when they learn in mitigation, where without a doubt this comes in at mitigation, that he has this disorder and it has them second guessing themselves. We must avoid that possibility. We ask for an order to allow its admission. We are not asking for carte blanche ability to lay all of that out in opening statement. This is something where we have no problem, where we take a step-by-step approach, but we've got to be able to tell the jury in opening statement that he has ASD. Thank you.
So what we've just heard from the defendant still begs the question of what's relevant and irrelevant in Idaho. And I think the case law is clear, to the extent there is case law, that the defendant's appearance when he's not on the stand is not relevant. I think that the court, if it has concerns about that, could add language to the ICG 202 that talks about the type of evidence the jury can consider, to say the jury may not consider the defendant's demeanor as he is seated in the courtroom if the court feels that's appropriate. I'm not sure it's necessary, because 202 specifically lists what jurors can consider, and the defendant's demeanor is not part of that. In response to your Honor's question about, or observation that there's no evidence from an expert here that the defendant is incapable of committing these crimes, the response from the defendant was, well, yeah, that's right, which is exactly our concern, because the defendant in his filings took what little was in the expert disclosures and then stretched it out to this conclusion that the defendant is incapable of committing the crimes, when the experts don't say that. I mean, they are essentially creating an opinion that doesn't exist. So, Your Honor, our request stands. Certainly the evidence that's being proffered about his demeanor is not relevant. It shouldn't be admitted. And if there's an issue that comes up about the defendant on the stand and his appearance there, I think we can address that as it comes up. Likewise, if the state opens the door to questions about the defendant's behaviors, which we are not intending to do, we can address the issue at that time. So we'd ask the court to defer any kind of ruling on those hypothetical situations. Thank you, sir.
You know, if we didn't have 2.5 years of media coverage to know how Mr. Kohberger's physical presence has been perceived, the state might have a little bit more credibility with that argument that it's not relevant. But we have extensive media coverage that refers to him as evil, as an incel, as looking like a monster with very dark eyes. And it's all based on their analysis of him sitting in the courtroom. Pardon?
None of that is his autism spectrum, what you just mentioned.
But his physical presence is what the media has been judging, which is the same thing that a jury is going to do. So my point is that for the state to say that it's not relevant, we actually have in this situation the ability to point you to the fact that that is not true. Because what the media has done, I mean, there are, even before the cameras were cut out of the courtroom, there were all kinds of zooming in and stories with experts doing body language studying about him, including the fact that this is how he holds his hands, and there's details about that. So it's disingenuous to say that he's not going to be judged by his appearance. That is exactly what jurors are doing. They're judging the evidence. They are staring at the accused. They're looking for an accused to be remorseful and emotional at evidence that makes everybody else feel bad. And he is not capable of doing that through no fault of his own. And there is, I just explained to you that there are studies that have been done and there's case law on this, that it's important that the jury be informed.
There's also a case law that says that none of what happens except in the testimony is relevant. So how do I square those two things?
Because
Or I give the jury an instruction that specifically says, don't judge this case based on anything except that you hear on that witness stand. And then if I do this, what you're asking me to do, I'm basically telling them, but that's okay.
well, the state's asking you to give a jury instruction that says that. We're asking
Part of
you
the
to let us
standard
put
instruction- Part
put
of the standard
testimony on.
instruction is that the jury may not consider as evidence anything other than the testimony and exhibits admitted in the trial.
Judge, I just quoted cases to you where we don't get to live in a state of denial, right? We can pretend, but that's not what exists in society.
I
So
have to
we
live
don't
in
get
a
to live in a
what
state
the
of
law
denial.
is my concern.
Pardon?
I have to live in a state with what the current state of the law is
And
in
I just-
Idaho.
Well, I just gave you
You
examples.
gave me no Idaho cases.
But Judge, you can have the courage to be the first one to set it right here then, because autism spectrum disorder is very real in our society. 1 in 59 people have it, 4 times more common in males.
I'm not in any way trying to downplay the those that may be diagnosed on the spectrum. I'm trying to figure out how do I do this where I have settled legal precedent that I'm supposed to follow that says the jury may not consider as evidence anything other than the testimony at the witness stand. They can't consider, they're not supposed to consider the demeanor of the witness. Now, I will say, having seen Mr. Kohberger over numerous days now, I haven't seen anything unusual in terms of his demeanor. But, I'm not, scrutinizing him on YouTube the way maybe others are. But I understand your concern, and I'm not trying to downplay it. I'm just trying to understand how I get there in light of the legal requirements that I'm supposed to tell the jury, don't consider any of that. Maybe the way is to say, the way the parties appear, what happens at counsel table is not evidence. You shouldn't be concerned about it, and it should play no role in your decision. Would that do it?
Judge, the proper way to do this is through testimony. I just went through a litany of cases where that's what the courts have said in other states is the way to handle it.
I don't think those cases were those cited to it.
They're not Idaho cases, no. But then it's an issue of first impression here, right? And so you get to make the decision and you can get it right. You can allow the testimony, right? I mean, if it's an issue of first impression and you're looking for guidance around the United States, then do what other states are doing. That's the solution, not a jury instruction.
I'll take the matter under advisement. The council cited cases that weren't cited in the briefing, so I'll need to look at those. All right, let's talk about the motions to strike the death penalty regarding the same issue.
All right, focusing now to a different phase of the trial and why this should be a grounds to not even let Mr. Kohberger be considered for death. There's too great a risk that constitutionally protected mitigation can be reliably assessed by a jury. The impairments cited by the United States Supreme Court in holding that the death penalty is unconstitutionally reliable for juveniles and people with intellectual disability apply with equal force to people with ASD, and specifically to Mr. Kohberger, given his deficits. Courts are expected to apply general legal principles from Supreme Court precedent to new facts. The United States Supreme Court just reiterated this in Andrew versus White, a 2025 decision decided January 21st, 2025. The general legal principle here is that the Eighth Amendment and its requirement of heightened reliability in capital sentencing applies. Unreliability exists when a defendant has an inability to present mitigation evidence, which creates an unacceptable risk of wrongful execution. The four impairments in Atkins, which apply here, are A, less able to give meaningful assistance to their counsel; B, demeanor may create an unwarranted impression of lack of remorse for their crimes; C, typically poor witnesses; and D, mitigating evidence of ID can, quote, be a two-edged sword that may enhance the likelihood that the aggravating factor of future dangerousness will be found by the jury. All four of these impairments apply to ASD generally and to Mr. Kohberger in particular. As to less ability to give meaningful assistance, extremely rigid thinking, he perseverates on specific topics, processes information on a piecemeal basis, struggles to plan ahead, and demonstrates little insight into his own behavior and emotions. He may understand the definition of mitigation, but he has no ability to assist us and understand if what might be mitigating and why. The impairments that he has go all the way back to his very young years, where he walked on his tippy toes, rocked on all fours for extended periods of time, could not engage in imaginative play, wrote his fives upside down and backward. He was provided with extensive supports in school. He was evaluated for ASD, but not properly diagnosed. And bring that to current time, where he is at age 28, where he has few personal relationships. He does not have any insight into things like the fact that he once volunteered at the Special Olympics is mitigating, or that he helped save someone's life on the job, and that's mitigating. He can see the logic in the word mitigation, but he has no ability to understand and help us develop a case for him for mercy. His demeanor, he has a limited range of facial expression, odd eye contact, and intense gaze with subtle rocking, sitting very still. This is important because of the impact that jurors assigned and give tremendous weight to perceived remorse or the lack thereof. So again, I'm talking about not phase one, but if we get to phase two, this perceived remorse and their decision about the death penalty, as evidenced, as I've explained, by the media demonizing his appearance. As a poor witness, he has difficult picking up on nonverbal cues. Tone and cadence are abnormal. Affect is stiff, and language is disorganized, repetitive, and oddly formal. He really struggles with making decisions, such as, like I expressed, the decision to testify. He needs instructions repeated to him. He's easily distracted on what is happening around him, or so focused that he's lost in the big picture. He perseverates on unimportant details, and these are symptoms of his disability that will either unfairly keep him from testifying on his own behalf, or alienate him from a jury and make him easily trapped on cross-examination. And the double-edged sword applies as well, because the stoic affect and incongruent facial expressions may be seen as a lack of remorse, an inability to react to emotional moments that call for emotion, which is often an aggravating factor for juries. Studies in our motion related to striking the death on page 22 to 23 cited the bias towards people with ASD. Again, the media coverage has repeatedly described him as soulless and evil. I want to address the issue of national consensus because the state pointed that out. First of all, the national consensus standard is not something that is required if you make an unreliability finding. But even if you determine that a national consensus is required, there is one because of the factors analyzed, in Atkins all apply to ASD as a class of person that society wants to protect. They are the same vulnerabilities. ASD individuals like Mr. Kohberger are labeled protected handicapped students, below basic academically, unique thinking and reasoning make intellectual function difficult to summarize, poor fine motor skills, not comfortable speaking or overly verbose, can't make eye contact, require repeated instructions. Those were all specific statements in his school records. The Supreme Court has not established a clear
Doctoral program?
pardon.
Is that before his doctoral program in terms of his academics?
Yeah, the school records that I'm reporting here were definitely for him as a small child, but I wouldn't say that that there weren't issues that were derived as when he was in undergraduate or his master's degree program. And the other thing that's important is that it's really inappropriate based on what the experts say to put more weight on someone's IQ and less weight and make that IQ overcome adaptive function issues. The Supreme Court has not established a clear methodology for determining when a national consensus exists. The court has looked at state legislators, but also medical and psychological research, international standards, and there is an rapidly increasing awareness of ASD across society, including in the legal system, as outlined in our briefing. As a society, there is a consensus to protect this class of persons. And if you don't agree that any of those arguments are convincing, then some court needs to have the courage to be the first to declare a consensus, and that should be you. Thank you.
Your Honor, I want to start with the Atkins decision because the U.S. Supreme Court are the experts that this court is bound by. And that court specifically found in Atkins that there were two reasons why the individuals they were contemplating could not be subject to death. And it was sub-average intellectual functioning plus significant limitation in adaptive skills. What the defense is asking is to eliminate that first critical component and look only at adaptive skills. And the defendant's not the first to try that. In Idaho, the Idaho Supreme Court has rejected that argument in Dunlap. Now, it wasn't about ASD, but the argument was the same, that mental illness has some of the same conditions that were talked about in Atkins, and therefore the Eighth Amendment prohibits execution. I would note that the Idaho Supreme Court did not even entertain that argument sufficiently to do a symptom by symptom comparison between the mentally ill and those who were found to be intellectually disabled in Atkins. Instead, the court cited, by my count, 10 other courts that had rejected similar arguments and said, we agree with them. I don't know how you can read Dunlap in any other way than the Idaho Supreme Court has said it does not violate the Eighth Amendment unless and until the U.S. Supreme Court extends it. And they haven't done that, and they still haven't done that. Now, on the national consensus issue, national consensus is a critical part of an evolving standards of decency claim. It's at the very heart of that claim. That's what it means. An evolving standard of decency requires some kind of national consensus. And the critical place you look for that are the actions of state legislatures. Not a single state has said that someone with ASD cannot be executed. They cited to 2 states in their brief to support their claim. Neither of them have laws that preclude this. In fact, their laws, both passed within the last 5 years, did add to the list certain mental illnesses, but they did not add ASD. That means those legislatures considered which mental illnesses should we add to this list and rejected the idea of adding ASD. So that's not the national consensus that the defendant would need for this type of claim. Based on Dunlap and the plain language of Atkins and the complete lack of any kind of national consensus, we would ask this court to deny the motion. Thank you.
I addressed the issue of national consensus initially, so I'm not going to repeat why that is something that you don't need to find. But I do want to point you to another resource that is really informative, because what we're asking is that you make this finding on the unreliability principle. And Scott Sunby has an article titled "The True Legacy of Atkins and Roper, the Unreliable Principle and the Unraveling of the Death Penalty." And that explains the court's pathway on how Atkins and Roper is focused really on why society protects people with vulnerabilities, and why people with vulnerabilities like ASD cannot properly be reliably mitigated in front of a capital qualified jury. And that's why you should strike the death penalty in this case. Thank you.
Thank you. I'll take the matter under advisement and issue a written opinion. Let's address what I have as to be the last item, which is the motion to strike the death penalty regarding discovery.
Your Honor, we are asking the court to strike the death penalty as well as issue some additional rulings in this case as it relates to the discovery issues. Your Honor, we're asking the court to look at this not as a Brady violation, but as a due process violation. And it's important to understand a little bit more about the discovery to do that. First, I'll start with defense counsel's obligation. In any case, defense counsel has the obligation to meet its constitutional requirements of effective assistance of counsel, and that means that we have a duty to investigate any of the state's claims and review the state's discovery. There's a heightened sense of that responsibility in a capital case. Death is different. That's been said time and time again throughout the United States and state courts as well. So we need to be able to review all of the discovery. We need to meet that obligation, and we cannot. 68 terabytes in our briefing. I won't repeat it all here, but
I don't have a clue of what's in there in some senses, because I don't know how much of that is music, how much of that is video and movies off personal devices, how much of that is things that no reason to look at.
Well, the problem is, Your Honor, there is a reason to look at it. There are tons and tons.
Why didn't you bring a motion earlier asking for intervention to have me do other things, and rather waiting to tie it to the death penalty at the end?
I'd say that's a bit of a mischaracterization of what's happened.
The first time we met, you told me about having received the state's discovery and the number of terabytes. And the first question I asked you was, have you looked at it? And you said, no, you hadn't yet looked at it. And we talked about the trial date, and I moved the trial date back a little bit for that. And I haven't heard a word since then that you haven't had enough opportunity to review the discovery or to do the discovery?
Well, I'm here to tell you now that we haven't reviewed all of the discovery. Over the course of the case, there have been multiple emails and letters back and forth with counsel about discovery. We've had motions to compel discovery. When I first met you, I was very candid with you about the size of discovery and that our team had not looked at it all. Since that time, we've continued to receive additional discovery. And probably most importantly, that brings us to now, why now? I think that's a fair question. Since we began with the expert disclosures, and I'm not going to go all the way back through that, I talked about that exhaustively, but that was a real turning point for us. That when you're moving along with a schedule and a pace, and in this case, especially with the sizable amount of discovery, and I want to tell you what's in there in just a second too, but we're moving along at a specific pace, and the expert disclosures, we've talked a lot about that, and those were not adequate. The court told the state to do a better job. We've talked exhaustively about that, but that disrupts the flow of everything that we're doing when that happens. We had worked diligently to get motions filed and to get our other motions that were being heard in January prepared and to meet our expert disclosure. And now in the time since January 24th, we've had repeated meetings with experts with new information here to find out what it means, new information there to find out what it means. And it just hasn't allowed for enough time to focus on the discovery. And that's not all. We have these motions in limine. We've talked quite a bit about the dollhouse and the issues with the dollhouse. That takes time. Everything like that takes chunks of our time. We don't have all the discovery reviewed. That discovery consists of thousands and thousands and thousands of pages of police reports. I know the court has a little bit of a glimpse of that. The court asked the state to give them Detective Mowry's police reports that he authored. I think it took him 10 days to get them all gathered up to the court. That's one officer. That's just one officer. We have, I think, over 15,000 photographs.
4 years in the fall,
No,
the homicide?
no. It's 3 years in the fall since the homicide. Mr. Kohberger was arrested.
Fall of 26 is what I was referring to. So 3.5 years.
The homicides happened in 2022, November.
May
So
26th
we are
November.
2.5 years since that happened. We're in 2025. Would be 3 years in November of 2025.
Happened in November of 2022. Oh, you're right. Never mind.
It's been a long day, Your Honor.
It's been a long day. I'm off it by a year, and I feel a lot older than that, than having aged more than just a year in this hearing. But regardless, at what point are you ready? Does that mean that in no case where there's a lot of data, can we have the death penalty?
Your Honor, that
Took on a new death penalty case since you came onto this case. Why would you do that if you were not having enough time on this case?
Well, Your Honor, when I agreed to take that case, we had a certain pace going in this case already. And then things have happened since that point in time in this case that have set us back.
The skeptic would look at this and say, well, this is what Judge Boyce did when there was a last minute discovery issue. This isn't the last minute discovery issue. And it seems like this could be viewed as being calculated to try to be a method to get the death penalty off the table by waiting until the end to bring to the court's attention the contention that you can't get through all the discovery.
I'd ask you to look at the things that have happened since our, I would say our status conference, the first time we met, when I was hopeful that we could get through a number of the things that we still had left to do. There are things that have occurred that have taken an extraordinary amount of time. There are a lot of things that we haven't had a chance to look at yet. We continue to go through discovery as rapidly as we can. We're just not going to get through all of it by the time we get to trial. Part of that is the way that it's organized. And that's why part of our request is to have the state give us the documents they rely on. And
giving hot documents is if they don't point out a document that you later say, oh, we should have known about that one. Now somehow they're culpable for not seeing the document the same way you did. And so that's why courts are very hesitant to employ that remedy, because it makes the state kind of do your job for you.
Your Honor, I would let the court know how we've received discovery in this case. And this has been a topic between counsel since the initiation of the case. The discovery goes to the police department, and then sometime later, the state gets it, and then they get it to us. So there's a delay already, but the documents don't come in any organized fashion. When you received all of Detective Mowry's police reports, those would have been scattered over probably a year for us to get. We litigated the video 1112 King video. We litigated that for about a year before we got the full copy of that. Those are all things that take time, and we are now months before trial with the cumulative effect of what's happened. And we now are faced with the issues with expert disclosures. Hearing the state today, I don't expect they're done trickling in expert disclosure after expert disclosure. At what point is it enough when we can be counting on that's it, we can get ready? The court's discovery deadline came and went. A lot of additional discovery has come past that deadline. At what point is that enough? I'm picking up more discovery today if I can meet up with the prosecutor.
Is it a penalty-based discovery?
I don't know. I haven't seen it yet.
That's part of my problem is I don't know, because you're very vague about what it is you haven't been able to do.
Well, let me tell you then. There is surveillance video from all of the university, all of U of I, and there's probably some pretty critical places where that discovery or where that video exists. I haven't watched that. I've sat down to watch it on several different occasions, and other team members have sat down to watch parts of it too, to try to see what's there. The way we've received it, it's not labeled in any fashion at all. I can open up a folder and I can look at something and figure out what date and time that's from. And there's multiple cameras and multiple days. There's no index, there's no guide to what it is. So I haven't looked at all of that. There's a couple of additional video footages that I haven't looked at. Now, if we want to start talking about cell phone data and third-party digital data, I have an expert who said it would take 3 years for him, an expert who knows how to do this, to go through every single piece of that. Now, he's been through a lot because we've had a little bit over 2 years to work on that. Not a full 2 years because we haven't had that discovery for the full 2 years. But there's quite a bit that I haven't looked at. I don't have an expert giving me even a report. We're not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant though. Recently, we came across a tip just in trying to work through some of these issues. We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know. We were disclosed a bunch of email communication between different law enforcement officers, different lab personnel. I probably have read about half of those by now, and different parts of our team have read different parts of it, but we don't have it completed yet. Those are some quick examples that I can give you. I've looked at every picture, and I believe I've read every police report. There's a lot left to do that could have things that are favorable to Mr. Kohberger. In January, I had to stop doing that because I had to start worrying about the expert disclosures that we didn't get. I continued that through February. We've responded to the motions in limine. We've responded to the dollhouse. We've met our deadline with our mitigation experts. We're meeting the deadlines that are set out, but there's only 24 hours in a day. This is what's happened here is not satisfactory. That the discovery is not in an organized fashion. It's not in a searchable fashion. We've encountered documents that have been locked, most critically the entire DeSales record for Mr. Kohberger's education at the DeSales University. Those were locked documents. They were a complete mess. It took one of our team members probably 10 days to get them in an organized fashion where we could understand what document went with what other type of classroom or assignment or other event. I will tell you about the motion in limine we didn't discuss today, the self-authenticating records. When we received the state's initial list, these are the list of things that we want to put in with a certificate. We went through those discovery folders, and those didn't contain just one document. They didn't even contain a document that made sense about what the state was trying to do. That took me personally about 10 hours to go through all of those folders of discovery so that I could write a response to that. The state replied abandoning wanting to use about half of those right out of the gate after I'd spent the 10 hours. And we come today prepared that the court was 100% right. Those pleadings weren't ready. There's not a packet with a certificate of authenticity for the court to make a decision on. The court was right. But that doesn't mean that I can't be prepared. Those things take time. And when we're talking about the amount of discovery that's left outstanding, everything that happens like that eats up those minutes. In this situation, Your Honor, it's not that we saw what Judge Boyce did in Vallow and thought this is a great idea. We are at the end of our rope doing everything we can. And I know about what Judge Boyce did. And I have to come to you and say, you need to do this too. This impacts Mr. Kohberger. I can't not bring this motion because somebody might think I was waiting to the last minute. I can tell you we weren't. We weren't. We've been working as diligently as we possibly can work on this case. We have understood the court's.
Have you gone to Judge Monson to ask for additional resources?
Well, Your Honor, we do have an additional resource. We recently added our attorney, Miss Barlow, to.
A team of another 5 or 6 paralegals, for example, to go through stuff.
I can definitely do that. I don't know how that puts the information in my head fast enough, but I can
That's the
definitely do
point
that.
of having litigated many very large cases, you have staff to tell you, here's an important document. And then that one comes to your attention from the, as you pointed out, the gigabyte or terabytes of probably pointless video cameras that nobody's ever going to rely on, that don't show a thing.
If I'd had a team of 5 more paralegals that understood the case already, that would be one thing. I certainly can ask Judge Monson for additional resources. I certainly can try to get somebody to understand what the issues are. I don't have a problem doing that, but that doesn't change where we are now. That doesn't change the things that have come up that have impacted our ability to prepare. I understand that the court has said this is the trial date, it's carved in stone. And I've done my best to adhere to it. And I'm here now saying that the death penalty needs to be struck so that there's fairness to Mr. Kohberger. The remedies for the court are to strike the death penalty and to have the state give us a list of Brady documents and the documents that they want to rely on. This is a huge amount of discovery, and we don't have the same resources of the state.
I'm going to get a list of the documents here in terms of exhibits in the next few days, I would imagine. I'm not sure. April, what is that date?
Well, it's just a little over a week away. Ours are due the same day.
Well, but if there's things on there that you didn't anticipate. This is a process where there's the ability to add things by your part if there's things that you didn't add, if you discover something else in there. But the point is, you will know generally the universe of documents that the state's going to rely on in 2 weeks.
I will know those. I will know those. And when I produce mine, the state will know what I can rely on, but I don't know what I don't know yet.
It sounds like you would never know what you don't know, given what you've told me. It's going to take, 18 billion years to get through.
Well, I don't think it'll take 18 billion years, Your Honor. I think that.
Well, it was several decades, as I recall, is what you'd said, or several hundred years.
I can promise you I won't take several hundred years, but
You see my point? That's what you said it would take to get through that, an individual. I have a hard time taking that at face value because that's not a realistic answer.
My realistic answer, Your Honor, is that we were working, and we still are working diligently, but the discovery was one of the biggest things that we were doing, methodically going through that discovery so that we could understand everything that the state had given us, even in its disorganized fashion. And that changed with the things that have come up over the last few months. Our entire plan, our schedule has changed to be responsive to everything else. And that's not Mr. Kohberger's fault.
Complex litigation generally, when you're in the expert phase. I mean, that's not unusual.
I guess, Your Honor, I think it's unusual when deadlines are blown by the state or not adhered to by the state, and our client pays the price for that. So I do think it's unusual. I think it's unusual to receive discovery where you might get 23 pages of a transcript, and then 4 weeks later, you get the rest of that transcript. We have had to match up discovery every step of the way. I don't think that's usual. I think there are things that have occurred in the path of discovery that are not usual at all. And I think things that have happened.
I guess my point is if the discovery is being provided in that way, this is something I should have heard about in September.
I advise
You did.
you were not
You had not yet gotten through things, but you didn't advise the pattern of the way you're getting discovery in terms of
Yes, you did.
incomplete here and incomplete there, et cetera. That's
I remember hearing it in the hearing.
I agree that that's new to Your Honor. I know that we discussed a sizable amount of recent discovery we had gotten. Those issues came up prior to this court taking the case over. We had talked about the way discovery was being received early on in the case. We filed discovery request after discovery request, in addition to talking about the mismatched way discovery was received. That has been put on the record. My hope was with the state's discovery deadline, with that cutoff date, that we'd be able to pull it together. My hope has been that until these new things have happened to shift us off the course that we were on. And I'm here to tell you about it today. I think it would be a lot worse if I stood up at jury trial and you said, is the defense ready? And I said, no, we haven't read all the discovery. So this is my opportunity.
Right, that would make me happy.
Well, this is my opportunity to let you know. We filed this motion several weeks ago. So the prosecutor and the court's been advised. We have been diligently trying to get through it all. We can't. It wouldn't matter if I had 10 more people right now, given the shortness of time with that. But I know that there are remedies the court can take. I understand I'm going to get their exhibit list. The court can order them to tell us what are the hot documents, where are the Brady issues. It's not enough just to give it to us in this volume of discovery. We need it identified, especially given the short time. But our position is that the court should strike the death penalty in this case. It will take the heightened level of pressure down, and it will allow us to focus on the trial phase only, rather than the mitigation phase as well. There is precedent in Idaho. The court knows. The
Circumstances were completely different, counsel.
I'm not saying our circumstances are identical, but it's a due process issue, just like was analyzed in the Vallow case. That was analyzed as a due process issue because counsel didn't have the opportunity to be prepared. And that was grounded in other case law. That was Riviera versus Clemente, Grover versus Florida, and Lopez versus Matthews. And those apply now. We do not have an opportunity to meet the state's discovery, even though we've diligently been trying to do so. And this is the appropriate remedy. And we're asking the court to make the orders for the court for the state's disclosures and to strike death.
Judge, in this case, the state has made every attempt to try to comply with Rule 16. 7 days after defense counsel entered her notice of appearance, she indicated she wanted everything that we had. And we started the discovery process. This was continued routinely throughout this case. Generally, documents such as police reports, lab reports, etc., were bait stamped and then turned over, and essentially turned over in the same way that we received them, in the same order as they were done and turned over by various investigating officers or whoever. We put a bait stamp on them. Photographs were done in the same fashion. Larger files, and I could say that, for example, most of the files that come from the FBI tend to be larger files that can contain a multitude of different things. Those were placed in an AV folder and discovered.
Were they meaningfully indexed?
I can tell you for FBI documents, the defense was provided essentially an index for all FBI documents because they requested everything that was on a shared drive for the FBI, and that was turned over with a searchable index.
Mention a problem because of the password protection of documents.
Yes, and we addressed that. Actually, we first heard of that in, I believe, April of 2023, and Mr. Thompson wrote a letter to Ms. Taylor saying that he understood that some of the PDFs were locked, but advised counsel they could get around password protection by hitting print to PDF and then saving, and that allowed those documents to be searchable. They were advised of this over 2 years ago. It's true there's a large amount of discovery. There was a 6-week-long investigation prior to a substantiated tip that led to Mr. Kohberger's arrest. So yes, there was a massive amount of discovery. We extracted cell phones for anyone that had any kind of connection to the victims. We gathered surveillance video for weeks, if not months, of random places throughout Moscow trying to figure out what happened. So to answer your question, there's a ton of discovery, and the majority of it is completely irrelevant.
Are you aware of any Brady information that is in the cameras that are not the ones listed in your route of travel? And
No, Your Honor, I am not aware of any Brady material, any exculpatory material that's within those videos. The defense is right. All discovery was routed through MPD. We have a central location for collecting all the evidence, all the information, and then it was sent to our office. And then it was primarily reviewed by myself and Mr. Thompson, given approval, and then immediately sent over to defense. Files were kept in the same way by our office as we've discovered. That's how they've been maintained. And the parties are just on equal footing in this regard. Defendant's motion is just replete with these mischaracterizations and just completely false assumptions. For example, they say that there's so many investigators involved on this case. While that might be true that there were many investigators involved on the investigation, those investigators don't help us in the administrative task of organizing and sending out discovery. Further, we do have a PBK case management system, but it is not at all the way that it is described in the defendant's motion. For example, we don't have this global search function. We don't have the ability to just generate reports based off of witnesses. Agencies can't just directly upload into our system. We just don't have that capability. The reality is we rely on a self-created spreadsheet. Throughout the case, defendant has filed over 20 separate requests for discovery. There's been 400 itemized requests for different items, and the state hasn't just simply responded with whether or not we complied. We directed them specifically to where they could find that specific item, if it existed, the location, the description, and the date that it was discovered. I would just go back to that massive dump that we were talking about of the 50 terabytes of data. Defense has had that for over 2 years. It's hard to, I guess, rebut a lot of the allegations because there's no specifics. They just talk in these general terms about all of this data. And I'm not totally sure how to respond other than we've given over the data as we've received it. And they've had the majority of it for several years. Most importantly, defendant has not specifically pointed to any particular piece of evidence that has been withheld or any actual prejudice suffered, and instead just points to the vast amount of discovery, which we have absolutely no control over. The state has in good faith complied with our discovery obligations, and there's just simply no basis for a sanction. And so we had asked this court deny their motion. Thank you.
This motion is not about withheld discovery. This motion is about discovery in the format it's in, the vast amount of it, and what's happened over the last few months that have taken us off track and our inability to be prepared. And that remains true. The 50 terabyte server that we received sometime in April of 2023 is the one that contains the U of I footage, and it contains a lot of footage around the town. We have been able to go through most of the footage other than the U of I. When the court asked the prosecutor,
Counsel, is there any known Brady material in the U of I surveillance cameras?
Not to the state's knowledge.
Your Honor, I think you'd have to watch that at various relevant times to know if there is or not. I think when you're thinking about Brady material, when we're thinking about video surveillance, and we'll go back to what we talked about the vehicle before and how Special Agent Immel's going to testify, there very likely are vehicles, light and color, white or silver, on all kinds of different cameras. Those could be Brady depending on what he has to say, but they should certainly be looked at. We're trying to look at that as quickly as we can to understand that. We've watched a lot of the video that's contained on that server. Also on that server are vast amounts of bank records, vast amounts of cell phone for all of the people that Ms. Jennings mentioned, the deceased and people close to them and other people.
They've indicated that their experts have examined that and found no connection between Mr. Kohberger and the decedents.
I'm grateful to have recently learned that. I mean, that's what we believed, but that was in that March disclosure when they said that they'd examined those, and those were computers, the 7 computers, I believe. It's that kind of thing that takes a lot of time. In addition to that server, there's all of the other information that comes in different ways. I'll give you an example of the delay. We received a lab report that was dated March 30th. The state received it March 30th, and this wasn't this year. This was obviously not this year. It wasn't even last year. We didn't receive it until May 8th. So the delay going from Moscow Police Department getting it, the prosecutor getting it, to getting it into our hands, that's well over a month. That's a long time for delay for the routing process. I think it's important to realize that the FBI index we have, you can't push a link and get to the document, but I do at least have that index. When we're talking about locked documents, the print to PDF, that's the problem. That's the steps, the additional steps that it takes when we're talking about thousands upon thousands of pages of documents. I think it's hard to imagine that there's not material somewhere in there that isn't favorable to the defense in some way. We recently found that, and we found a pretty good lead that we're trying to follow up on. And that is really what it comes down to. This is not follow up on. And that is really what it comes down to. This is not organized data. It's not easy to go through. We've made substantial steps. Due process requires that something be done, and striking the death penalty is the thing that must be done.
All right, well, I will take, it'll help to review file. Number one. Number two, with respect to the witness, with the exhibit list. Now, I will say the exhibit lists need to be specific and detailed, not exhibit 3 video, not exhibit 3 video from X bank. It's exhibit 3 video from X bank minutes 25 through 27. Detailed, specific. I would also look at as a issue whether it might be appropriate to require the state to certify that it is unaware of any exculpatory material that it views as exculpatory, that it would, for example, feel it would have the obligation to bring forward if the defense were unaware of it, that has not been identified by the defense throughout the motion practice and discovery and their exhibits and witnesses, et cetera. I will look at the issue and issue a written opinion on the matter, because I think obviously at a minimum for appellate purposes, you'll want that. So with that, I don't believe we have any other motions to take up today. Did I miss any?
Your Honor, we wanted to approach the court in regard to the review of the jury questionnaire and whether that can be conducted remotely, and when the court would like to do that.
Yeah, so I haven't had a chance to look through your responses to my proposed jury questionnaire. I will do that. Keep that just as a tentative. We can do it by Zoom or WebEx or something like that remotely. There's no need to travel down here to do that. And it may be that I simply just need more time and we'll tell you, let's take it up at the pretrial conference. I think we'll have time if we get it done at that time. So
Thank you, sir.
I didn't anticipate that I would actually get to the point where I would have given you my draft of what I think it ought to look like by this deadline. So that's part of the reason I had calendared it. So.
And I can tell you, we very much appreciate that the court was able to provide us with your draft, because I think that simplified the issues. And as you review them, they're just a handful of things that are potentially in dispute.
All right. Anything else from defense?
Your Honor, with regards to the exhibits, because they are now scheduled to be due the same day, we'd actually like to see if we could have an additional week.
I will give you additional 1 week after the state's exhibits are due.
Thank you.
All right. I think with that, we are adjourned. Thank you.
Wow. What I mean, wow. That was a long one, folks. My apologies, but thank you guys for hanging on. Wow.
That was a lot.
Well, I mean, and there's a lot of emotions. So, it was to be expected. There is a link pinned in the top of the chat. And if anybody else wanted to join us to express any feelings, opinions, theories, thoughts, Eddie?
I did find the answer to when the defense filed the exhibit showing how the discovery is coming in.
Oh yeah,
And
me and you both agreed at the same time that as soon as he said he had no idea, bullshit, you're lying. When was it, bud?
so this is way back in June 27th of 2023. There was a hearing. And in that live hearing, I think it would have been a hearing that, like independent news channels were airing back in those days, right?
Okay.
Like Court TV or whatever.
Yeah.
So during that hearing, it says in my notes that Anne stated that she filed the exhibit on the 26th of June. So in other words, one day prior to the hearing. So I looked in the court record and I cannot find it in the court record. I wonder if it must be under seal.
Probably.
I know that there are some things in the court record that are no longer in the record, so to speak. They must be under seal, such as, we all saw the affidavit in support of motion for out-of-state service serving a subpoena. That was March 22nd, 2023. That's the one that talks about Richard Batanti
Yeah.
interviewing Bethany Funkhead's information material to the charges, blah, blah, blah.
Yep.
Okay, so that one's not there. So anyway, 26th of June is when apparently Anne filed this exhibit for the court showing how discovery is coming in.
And Dan just said that was the original date for the preliminary hearing, 26th or 27th. I think he's right. Excuse me. So yeah. So it was known. Maybe not with this judge, but yes, it was handled.
Well, but indirectly it is with this judge because this is now his case, his responsibility. He, if we know this case,
he should have followed up.
How
Yes,
much
sir.
more is it his obligation to know this case?
Well, you saying that, how many times did you notice that he doesn't seem to know shit about a lot? Many a times he referred to the fact, well, I didn't know this, or I don't know that, or I didn't know that. Why don't you? Is it or is it not when you take on a case? And anybody can answer this question for me. But as a judge, if you new or not, I don't care if it's new to you. When you take a case on, are you or are you not supposed to, or is that judge not supposed to read that entire everything, look into the whole thing so they know what the hell's going on? Am I wrong in saying that?
This is not my field, so I wouldn't know how to say it, but just my natural using common sense and logic would say absolutely you'd need to know that.
I got to agree with you, bud.
How else could it be? You're how can you be unbiased unless otherwise?
And how can you rule on anything? You're supposed to know before them what's going on as they're presenting it to you. And I noticed that he did know some things ahead of time, just not everything. So who's slacking here? Okay.
Yeah, he knows select things ahead of time. Conveniently.
Exactly. Yes. This was a complete and total disaster. I'm going to say something, and if I offend somebody when I say this, sorry, not sorry. Whether you believe that somebody in any case is guilty, welcome. Oh, hold on. You got something going in the background, ma'am.
Oh, I'm in the kitchen. Can you hear my TV now? I turned it down. Can you hear me now?
Yeah, I think you're okay. Okay. So welcome. But let me state this real quick. Whether this case or any other case, I don't care what it is, whether or not you think the person is guilty, innocent, whatever it is, the fact that ASD was brought into this, okay? And I'm saying this from a personal piece of me. Okay, so people can disagree. I don't care at this point. To make statements and make blatant, ignorant, uneducated, biased, disgusting statements about something like that, shame on you. That's because there's a lot more I want to say right now, but shame on you. You need to grow the fuck up and be the adult you're supposed to be in that sense, guilty or not. we can all have a conversation about this case and agree to disagree on things, and it happens all the time. But to throw something like that in the middle of something, no. Any ounce of respect I would have for anybody like that is bye. That's all I'm saying. Sorry about that, and welcome
Thanks
again.
for saying it. It needed to be said.
Oh, buddy, you have no idea how hot I am over that. Anyway, my apologies, folks, for my language and my bit of attitude I have, but no. Welcome, Shorty. Thank you for joining us, dear. I hope you're having a good day. Eddie Hemisphere, I appreciate you joining me up here too, and sticking through all that. That was a lot of stuff to listen to and think about. So,
Oh, you had a 9-hour live before.
oh, I've done it, but I think we did do a 9-hour for one hearing one time, which was a lot worse than this. But this was just ridiculous, in my opinion. The whole thing, the judge, and I'll say this again, sorry, but he was an asshole. He brought his personality into this. He was bored. He was irritated and aggravated. What I don't care what your problem is. You are the presiding judge. Deal with it, bro, or tell him you don't want it. Okay, that's all I can tell you. But besides that, don't bring your irritation into this. This is a death penalty case. Somebody's life was on the line. 4 lives were lost, and there deserves to be justice for that. And if you can't provide that, then get the fuck off the bench. That's all I'm saying.
I'm sorry, I was muted. I said hi all to you guys, and I just realized I was muted.
Oh,
I'm sorry.
That's okay.
I was just talking away.
Oh, welcome again. Thank you. But and again, my language, my apologies.
Oh, no, you're fine,
Sorry.
sir. You speak. This is your panel. You do what you need to do, sir. Clean house. Don't apologize. Speak at your will.
No, and I'm not, Jeff, that was more than a question. You know what you said. You know what you did. We're not going to get into it because I'm going to go off, and I don't want to do that, okay? Out of respect for everybody else in here. I'm not going to do it. So leave it alone. Don't talk about it anymore, and we'll be good. Just let me cool off from it and let me move on.
Shoot,
Welcome,
I got a channel and I clean house. You do your thing, sir.
I don't like to do that. I don't do that on a regular, but that burnt me up like you wouldn't believe. Sorry.
So how you doing?
I'm good. It's good to see you again. It's been a while.
I know. Well, yeah, I disappear from time to time. Not that I have to. It's just medical reason, but that's a whole nother conversation, sir.
Understood.
So how's everyone on the panel?
Probably irritated as much as I am. Just saying.
Oh, now come on.
What are your thoughts on this?
I just got through watching the trial and I seen where the judge was a little irritated. I think he's constipated. What do y'all think?
He's something. He's something.
I mean, I gotta throw something out there. Come on, guys and girls. Come on.
He's a curmudgeon.
He's a curmudgeon.
He just seemed like he was very uptight, or he had some hemorrhoids that needed to be some preparation age. Come on, I gotta throw some humor out there. I got a good sense of humor. Come on. Work with me.
Eddie called him a curmudgeon. I haven't heard that since I was in 3rd grade, so that was a good one, Eddie.
I don't know. He just seemed like he was real. That lawyer. I mean, come on. I mean, I'm down the line 50-50 here. Look, yes, there was some lives that was taken, but I am for, what is right. I'm here for fair is fair. What is right, what is wrong. Okay.
Yep,
and that's the way it is. It's hit or miss, or I'm gonna rip your head off, pull your guts out, and you know the rest. Okay. Out of respect for your channel. But I am also blunt. That's a whole nother story. But anyway, moving on. But the point of the matter is that judge, I could tell, was very uptight. And he was not cutting any corners with that lawyer. I could tell that. But, the defense team was also letting her, let them know that, look, they had sent everything and she was looking at seemed like every, well, we can't do this and we can't do that and we can't do this. And it's like, look, if you can't get your shit together, get it and get it together. Because it's like you're looking at every excuse. But look, if this person, like, just say, I'm gonna use me. I'm gonna put me at the whole thing. If I went out here and I done this, then okay, I want the best lawyer, point blank. But then you got the defense team that's going to work against me. Like, okay, yes, she did it. Then I got my lawyer saying, okay, take the death penalty off the table. Look, if I know I did it, then I did. You know what I mean? Come on.
I agree. I agree. And I,
And I got the whole world out here saying, look, that, blank and blank did it. She did it. There ain't no ifs, ands, and buts about it. You know what I'm saying? I mean, come on.
I do, but I do want, thank you for saying that. It just sparked something. And then Eddie and, oh my God. The other gentleman here, how to say your name again?
Hemisphere.
There we go. I thought that was it. Okay. So did you guys catch, and I hope you did, because I did. I think everybody did, where she stated that they did just receive information, the defense did, in regard to a possible alternate suspect on it. And I thought that was quite interesting. And as soon as she said that, if you noticed, Ashley and Bill went together in a little conversation there as soon as that was said. So that's quite interesting to me as well. And I gotta wonder now, as she's stating that all of this stuff is all mixed up, and she said that she had an expert look at this and said it would take 3 to 5 years or whatever it was to go through all this.
Mm-hmm.
What else is buried in there? Who else is buried in there, in my opinion? Okay.
Exactly. Ding, ding, ding.
That is interesting as hell to me. And I gotta wonder, I said this the other day, you guys, if this was, they're lying. The prosecution lied many a times today. I'm sorry, but they did. Welcome, Kylie. And stated that they gave them the discovery as they received it. I don't believe that. I just don't at this point. And I said the other day, and I truly do feel that they did this on purpose. They handed that over to her that way, knowing that it was going to take forever and a day to get through that, and that she very well could miss something. This is my opinion once again. Nobody has to agree with me, but that is truly how I feel at this point. Because there's one. Now I wonder what else is left in there that they have possibly mixed up in there that she could find, and God knows if she'll find it. I'm just saying, but that's a problem.
Danger Zone is right. That's not your theory, Dago. That's just the truth. That's the fact of the matter.
Oh, agreed. Call it however you want, but that's, yeah, Dan, you're right.
You call a heart and a heart's a heart.
And that's what it is. This is exactly what we're looking at, guys. And they can say whatever the hell they want. I'll tell you right now, Ashley Jennings is an accomplished liar as far as I'm concerned. And she doesn't do a very good job at it because her eyes bulge when she's lying, period. So I'm just over this bullshit with this entire prosecution.
2.5 years. I mean, come on.
It's beyond ridiculous now.
Well, I tell you so.
Go ahead, sir.
I got to give Dago his due for noticing that about Ashley Jennings. She's an accomplished liar, and her eyes bug out of her head
every time she lies. Yes, sir. It's absolute. I'm pretty good with body language, thanks to my wife. I love her. But every time she says something and I swear it's a lie, the eyes get big like this every time. So do what you got to do, Ashley. But people see it.
Right. That's what I was just about to say. Usually you can tell in the body language if you tell by the eyes. If they look away down at the bottom of the floor, if they go to the left, they go to the right, or if they're not looking straight at you, usually there's something going on. And if they're not looking straight at you, there usually is a problem. And with me, I do hand volume because of the situation with my hearing issue. So I'd rather look at your lips. So if I'm looking at your lips the entire time, that means I'm looking at you directly, mostly at your lips, and my eyes are looking at you. But majority of the time, usually 90%, I'm looking at your lips. You know what I'm saying? But I'm focusing on you. My eyes aren't looking at the ground. They're not, here, there, and everywhere else. So what does that tell you? I'm looking dead center at you at the whole entire time.
Yeah, no, I get it. I agree. And Dark Bay using terminology like not that we're aware of and etc. That's another. Yes, I agree with you on that too. 1,000,001%. Kylie, this is the reason why I can't quit smoking, dear. So I feel you on that one.
Too much stress, right?
I have tried. It's not going to happen until this is over. So, Eddie, anything else that you can, other than what we know, okay? Anything else that you wanted to point out or that you pulled out of this at all, other than the
I just feel that, it's a shame, and all due respect, my heart goes out to the families and how much that they have had to endure. And I'm going to keep this short because I know that many people do know that these families have had to endure on this a lot,
Of
because
course.
not only each day goes by that they are victimized and victimized each and every day, that it is not only talked about on YouTube, that, you know, they hear about this, it's in the paper, it's in the news, this comes up constantly. This does not rest until the day that they get a verdict. I mean, does anyone not understand this?
Of
This
course.
is what is heartbreaking. So the day that they actually get a guilty or a non-guilty verdict, then, you know, does he walk free, or does he get the death penalty, or does he actually go to prison? Those are your three options.
Yeah, and it needs to be a true verdict too, based on real justice. What were you gonna say, Eddie? I'm sorry, but yeah, I agree with you, Shorty, and I appreciate that statement too.
When they were discussing the neurobiological and physical
Mm-hmm.
talking point, did you notice that she brought up shower curtain?
Yes, I did. Unfortunately,
Isn't
God,
that
I did.
interesting?
Yes, I know.
And I would like to rewatch that at some point, because was she
We're
talking about like the mainstream media right in there?
I believe so. Yeah, yeah. And my plan is, Eddie, actually, that you said that is to give this, because we have one more tomorrow. Once they're done, maybe over the weekend, I want to come back in and break them down little by little and take it apart piece for piece and talk about it. So that sounds like a plan to me. Um, and go from there. So yeah, I think she was referring to mainstream media at that aspect. I do believe.
Yeah, I think so.
Um, yeah, that was interesting. That was definitely interesting, and I just can't get past. I can't get past how he blew off the dyspraxia, the ASD, all of that, and was arguing that point. And then God bless you, Alyssa Massoff. She impressed me today. I'm not a big fan of hers, and I haven't been until today. The way she put that statement out there, both of them statements she made two very strong statements, you guys, and I'm very proud of her for that, and that defense team for that. That was absolutely amazing, in my opinion.
Mm-hmm.
Yeah, there's a point at which they both knew they were just spinning their wheels, but they have to get it on the record, and they're making a good record of it.
Well, I
And
think she
keep
got to
saying,
him. I think she got to him, Eddie.
yeah, absolutely.
I think she
He
actually.
put him on the spot with, you know,
Yep.
challenging him to be the one that has the courage to be the first to begin that trend,
Yep.
a necessary trend.
And then he tried to throw out there that well, these aren't Idaho cases. That's great. That makes it even better, in my opinion. Sorry if I'm loud, you guys. You might want to turn down a little bit. But that makes it better, in my opinion, because let's be the first state to do this. Be the first judge to step up and do this. And how he couldn't even respond to that. All he could say was, "I'll take it under advisement." So she got in his head with that. I promise you, she did. She did amazing.
Definitely.
She did amazing. And I'm glad that she put that out there the way she did. It needs to be heard. It needs to be seen. All of this stuff does.
Yeah, and sadly, that's just lip service. That's so he looks good, you know, because this is public and everyone can see it. So, yeah, she kind of held his feet to the fire there, and that's the best answer he could give while saving face. But his written ruling will prove.
It'll prove answers. Yes,
otherwise.
you're right.
Yeah.
We'll see. We'll see. And I'm thinking, I'm wondering, did she put it to the point where he may not have a choice? And then we'll see what goes on. That's what I'm saying, because I have my thoughts as well as you do. We know. And I'm telling you, this was such a mess today. I mean, this guy, I'm so disappointed in this judge by all means whatsoever. Shame on him in a lot of ways.
You know, go ahead.
I know a lot of people say it was stated that a lot of the stuff in the beginning with the emotions that the prosecution had agreed with those already. And I understand that. I get that. And you're right about that. But I think the reason, you know, because it was stated that it was a waste of the court's time. I think it was done because of the way the prosecution handles certain things. that it's on record now, okay? And they agreed to these things, so now they have to stand by these. And if they don't, the judge and the prosecution can be called out now at this point, and it's there. So that's why I think it happened like that, because they had agreed to these things. Yes, very true. And yes, it could be seen as a waste of time, but that's why I think they did it. That's my opinion, of course. And I think we're going to see that they have no choice now. They have to stand by the things that they stated. That's my opinion again. And again, we'll see what happens. Thank you, SRB. Go ahead, guys. I'm sorry. I'll stop rambling now. I felt really strong about that.
No, you're good.
I'm with you on that because it's like I said earlier about Cyrek. I'm shaking my head about that too. That's very unfortunate. And now that the model of the house, he allowed that in. I mean, we don't know. There was an expert that said that it wasn't right. There's a lot of things that was wrong with it. But
absolutely,
the big deal is Cyrek, because that's huge to the case. Why not address it now? Go ahead and address it now and find out what's going on, and not wait till you get the trial and then do all that.
Well, Eddie pointed out a very good fact about that whole thing, Hemisphere, and it's absolutely correct in my opinion too. The judge had a pre-written statement about that whole thing. He was ready to go on that from the beginning, okay? And you could see it on his face and the way he explained what he said. As soon as that got brought up, boom, here he comes with it. He completely avoided the 7-day thing. He wouldn't talk about the 7-day. That's all he had on that, though. I don't care about the 7-day situation. It's bullshit as far as I'm concerned. The FBI gets what they want to get, when they want to get it, however they have to get it, okay? So the 7 days, in my opinion, is a joke. That's an excuse that they're going to stand on top of that hill to the end of time with, and I think it's absolute bullshit. Absolute bullshit. Thank you.
Well, it's like the other day when we was looking at listen to the 911 call. We're trying to picture it in our minds about what would it look like if we was to walk in that door, and how everything was situated. And now you're telling me that, okay, we got a model, but we really can't prove to you how it was all set. You know, we can think, well, if we walk down the hall, we can see Xana laid passed out on the floor.
Right.
But we don't know if that door was cracked, it was wide open. Where was Ethan at? Oh, did we go upstairs and look for Katie and Matt?
Well, I don't know if you caught it, you guys, Hemisphere, on what you're saying. They did state that Emily went to the top of the stairs and stopped and went back down. Did you guys catch that, by the way?
Yeah, and that implies that they were on the first floor.
Yes.
Or right where all the cars are parked.
Yeah, they were on the ground floor level, and she went to the top of the stairs, which I'm guessing is by the stairs by the front door, and stopped and came back down. Didn't see anything, they said. So that tells me then, going with what you're saying, Hemisphere, there was nothing in that area there, that living area or the hallway. It had to have all been in Xana's room behind that door. So that will kind of verify that, in my opinion.
Okay, I got a question.
Yes, Tomboy. Welcome, dear.
Okay, so the old bearded, wonderless, whatever he is, stood up there and said that Kohberger turned off his phone.
Yes, he did.
And then he went on and on and on, but still going back to he turned off his phone. Okay. But then you say you don't have the reports for 7 days.
Yep.
How do you know he turned off his phone?
Thank you. I'm glad somebody caught that. That was in the very beginning when he first started talking. They don't know that he turned his phone off. That's the whole point.
The only one way they're going to know if he turned off that phone is if they saw those records. And Ashley James has those motherfucking records. I don't care what she says.
Thank you. Thank you. There's your answer, folks.
But the only way that you would know by the turning off the records would be the ping on the towers.
The point is that she's denying that she had anything. And Sai says that she clearly did. They need to bring in that. What is that guy's name, Tomboy? Because the judge tried to say, you haven't given me a name, or you haven't given me this, but they did in that. He did in that document.
Oh, the guy from the GLDC.
Well, the guy, yeah, the other
Or
guy.
the guy from AT&T.
That's it. The guy from the other than the GLDC. Yes. He's right there. Bring the man in, let him testify. Why didn't that happen?
Yvonne is 100% correct. The 7 days are only relevant to the GLDC. The
They went
FBI
around
did
that.
not go through the GLDC, so those 7 days should not matter.
They are
And that's what
irrelevant.
Sky Ray was saying in his paperwork was the 7 days don't, it's not a big deal because the FBI already got the records.
Exactly. And that's what that judge had to know that. He's not that dumb. Okay.
And remember when he said that the defense filed or the state filed some paperwork to don't destroy the records, so to speak?
Yes.
Well, if you can't go back to the time, because remember they didn't have them back then, what do you need to keep the records for?
Wait, say that one more time. Sorry.
She filed something with AT&T to not destroy the records.
Not destroy the records, right?
And then but if you don't have, you said that they only go back to 2023.
Okay.
So why are you worried about them destroying them if they weren't available to you anyway?
Good point. Yes. I see what you're saying. Yeah, that's a good point. And listen, on that same topic right there, think about this for a minute, okay? AT&T is a global company, one of the biggest, most powerful cellular companies in the world. Okay, they've been around for a long ass time.
Mm-hmm.
They have access to every bit of everything.
Exactly.
Involved, okay, so the FBI, secondary. I said this already once. We know what the FBI has access to. Anything they want in the world, in my opinion. Okay, and can do whatever they need to do to get to that, as we've seen. I will never, ever believe, just like Snapchat, for instance, okay? And Snapchat, when a Snapchat message is sent or you receive it, it disappears within minutes, per se. And it goes away, you never see it again, correct? Wrong. You can go in, see any of these sites, any of these apps, any of these things like this, and get what you need to get if you are the right person and you have the right abilities. The FBI has texts that do this kind of shit daily, every day. So 7 days
Yeah.
or not, or 10 days or 15 days or 4 days or 30 days. I don't care how many days it was. They can get whatever the hell they need, and they did. End of story. That's all there is to it. Just as it was stated, like Eddie said, that GLDC shit doesn't exist at that point. It doesn't matter. They went around that.
So
There's
the
the
7 days shouldn't matter either because
It doesn't.
and he has the email from Ashley Jennings saying, from the FBI saying they went around the GLDC.
Bingo. And that's why he didn't. That's why. Oh my God. I was screaming that over here, you guys. That's why he didn't bring up the 7 day shit. That's because it doesn't stand. It doesn't count. It doesn't matter. And that judge knows that. That judge knows that.
Chick,
He's not.
the specialist that the defense has all that information of what they were on Snapchat and checking her job status and all. He has all of that.
Every bit of it. Every bit of it. I agree.
Yeah, in all due respect, in the situation, FBI, any of that can get any of that because, just to let you know, I was involved in this situation, not in a murder case, God forbid, no, but I was in my daughter went missing, and they go through your phones, they go through everything, and they can know everything down to your drawers, okay? And if they want it, they can get it, and you're right. So I don't understand why this judge wasn't getting it. That yeah, you're right.
Oh,
This
I
is
think
I
this is
feel
that
like he
crazy.
was protecting the case. That's what I feel. He was just protecting the case because he knew. That's like the Cyree deal. If he would let Cyree in and let him testify today, there was no doubt in my mind. We'll be talking about something totally different.
What did
All
you
right.
let me ask you, Tomboy, with what he said and what she said about Cyree, what do you think is going to come from that now at this point, if anything at all?
Oh, I think he's still going to be able to testify at the trial.
Do you think that they're going to allow for him to explain this situation that Hitler seems to think doesn't exist?
Yeah.
Oh, sorry, Eddie. Hold on, buddy. The link should still be pinned out there, bud. Just click it and pop back in.
Oh, I'm sure that they have no other choice because if he's a witness, then yeah.
Yes, Chickbait. AT has the specifics of what they were doing, who they texted, the photos, all that stuff.
Because if he goes under oath, I mean, he has no other choice.
I don't think they can throw out his testimony
I don't
because
think so either.
he's been certified as an expert witness.
Exactly.
Right. That's that's what I was just getting ready to say. I mean, if he isn't, a witness in that and everything, and he's, has stated blah blah blah, that's okay. Say for example, okay, I've done nursing, okay, and I have seen gruesome things, and I have been witness on things or whatever, and they'll be like, hey, have you seen such and such at a home? And I'll be like, yeah, and they'll be like, okay, what spots? And I'll be like, here, kitchen, living room. Mrs. Roper in the living room, Mrs. White in the dining room. Do you see what I'm saying? So
Yeah.
technically, by law, if you're on the stand, you would have to say Mrs. White in the living room with a candlestick. I'm just trying to use different things.
I get it. Yeah.
Because of your channel, blah blah blah. You know what I'm saying? So you don't
It's
get in
okay.
trouble.
No worries.
You have to use different slang words. I'm sorry, because I've got a channel.
It's all good. Thank you.
You know what I'm saying with the gravy, bowls,
Yeah.
mashed potatoes.
Well,
But yeah, I mean, I get what you guys are saying.
Oh yeah. Yvonne said Hitler can stop Cy from testifying, and I'm sure he can. But
Right, you're right. Yeah, because he's sounds like a judge that it's got like some issues or something. You know what I mean?
he's just an asshole. Period.
And this is a whole nother judge. Constipated.
It's crazy.
Right.
Unbelievable.
Definitely. No, you guys, we don't have to say unalive. I quit doing all that stuff a while back because I don't like it. It doesn't. We're real life in here, folks. So we act.
Yeah, I know. I just try to be courtesy because
I appreciate you. Yeah, I do.
Yeah.
All right, Tomboy.
Because of everyone's channel is different. Because there's some people that go by the books on their channels and stuff like that, sir. And that's all. And I've got a channel, and I'm not monetized, so that's why it's
I get it.
on certain channels you have to go by it. Some people
Sure.
go by the books, blah blah blah, and then on mine, yeah.
Absolutely.
I didn't know. That's why if you notice, I'm trying to use different words, and people are probably thinking, "Where does this shit come from?"
Oh, it's all good. It's all good. And yes, Yvonne, if they do try to stop it, I mean, it's obvious. I still feel like it's very possible that Bryan's going to be convicted of this, but I'll be damned if he doesn't have an appeal, like all sorts of stuff for an appeal, guys. And the
But has
appeal,
anyone ever been in one of those homes that they're talking about? One of those college campus frat homes like that? And how, like, you got the down floor, the middle floor, and the up floor. Has anyone in the group, because I can't see the chat, can you tell me whether if anyone is saying yes or no? Like, kind of give me like a vote.
been in a 3-level house? Or
Yes.
just I live in one.
Okay, so you kind of know, like, if someone's on the very bottom, someone's in the middle, someone's on the top. Okay, like if you've been partying and if you've been to a sorority, I'm gonna go with my speech here, a sorority house and you're
Mhm.
partying. Okay, check this out. This is only my opinion of the version of Brian. I can't pronounce his name well, but anyway, moving on. Let's
Okay.
just give an a version detail. Let's just say he's been there, and this is my opinion of it. I think he's been there. I
Mhm.
think he knows the house well.
Okay.
Okay, for him coming in as fast as he did. Okay, because of the time frame that he was there, knowing how far of a distance of a drive that it is. Right,
Mhm.
right. Is everyone with me in the chat? Okay.
Yeah.
Notice that he gets there at that certain time. He knows everybody, he's chilling, and he knows that everybody's there, la di da di da. He's got a
Yeah.
crush on the girl, blah, blah, blah. Okay.
Okay.
Everyone with me. Everyone's with me. All right. Anyway, moving on. So everyone's chilling, everyone's kicking it. A Uber driver pulls up with some vittles. Everyone's still kicking it, blah, blah, blah. He's thinking that the girls are alone. He doesn't even think that the dude's even there. Okay. Right, right.
Okay.
So he's thinking, well, I'll just go up and kick it, whatever else. Oh, he gets up there, sees the dude there. That's when a scuffle goes down. That's when bloop, bloop, do 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 do. Then he goes next door. Those two are whacked off. Oh, girl sees everything that happens. She's all messed up. Comes out one, comes out two, comes out three, goes back in. He slips out, gets back in his vehicle, and goes home. Bam, over. What's
Okay.
y'all's verdict? I just summed it up like real fast.
No, I get it. Yeah. Well, I mean that could be how that happened with anybody that whoever did it. But here's my problem with all of that.
Okay.
From what we've understood at this point, he wasn't even there. So, and that's based on the cast information
Okay.
and so on and so forth. So, if he wasn't there,
Mm-hmm.
whoever did it did it.
Okay.
I still believe, and I heard also, I don't know if anybody else caught this either. I wish Eddie was
Mm-hmm.
still here.
Oh, where'd he go?
That I think his phone bounced him out, which is fine.
Oh.
But that they believed at some point it was brought up 2 perpetrators, 2 weapons. Now
Okay.
that was stated at some point that it's in one of these
Yeah, I
documents
heard that.
they had. So that's interesting to me. Okay.
Mm-hmm.
Very interesting. No, I haven't yet, Monty, but I will soon. No worries, dear. Thank you for asking. Yeah, 2 people, 2 weapons. Those were exact words that were stated today. I heard it. And that does make sense to me. But I don't think one of them is Bryan because he wasn't there, you guys. I'm telling you, the man wasn't there. So whoever the 2 did it with the 2 different weapons, it makes perfect sense. I'm just telling you. It's obvious that it's in somebody's paperwork because they stated it today, and they've looked at it in a sense that we're gonna go over that again when we go back through that whole thing.
So
That really perks my ears up.
you're thinking that it was 2 people that did this?
I believe I've always believed that there was more than one perpetrator. There could have been even 3 at some point, but I'm just saying, yeah, 2 perpetrators, two different weapons. So that was real interesting to me. Somebody has that in their paperwork, like I said. And I'm telling you, that is where they need to be looking. Period. And the fact that it was brought up tells me, like I said, they've been looking at that. Now we hear today again that there's information about another alternative suspect. There we go. Like I said, guys, I said from the beginning, many people in here have said that they do not believe that this man or whoever did this alone.
Well, I mean, honestly and truthful, out of all due respect, I mean, on a scale of 1 to 10, I'd say about a 7. I mean, I wouldn't say that he done it probably all by himself. I mean,
It was proven that one person could probably do it.
right. I mean,
But I never believed that was the way it was. And yes, the defense,
right. But I mean, you got to understand. I mean, there was, confrontation, about, popularity, blah, blah, blah. And she did have some confrontation, but I don't think that the confrontation was all just on Bryan, okay? And there was the confrontation that she was having some problem with another kid. And I do believe that that other person did come up. But don't you think that that person has come up kind of late? Don't you think?
I mean, there was somebody that was brought up, Shorty, in the very beginning,
Yes.
the first week, okay, that we looked into him in here. And then all of a sudden, he's gone. They got Bryan, he's gone. They don't speak about him again. They don't look for him. They don't talk about nothing. He's
Mhm.
gone. Nobody has
Right.
a clue where this guy goes. Nobody talks about it. Nobody thinks about it until all this new shit started popping up. And I'm telling you, he's probably one of the other ones. And I believe that his DNA actually popped up as one of the other DNAs that was found. Okay.
Mhm.
So there's some other stuff in the background with this that's actually pretty relevant, in my opinion, that needs to be looked into. But once again, they're not even thinking about it because they got their guy. This is where they're at with it. They know what they're doing.
Right. And see, sometimes that's what happens is sometimes, like I said, 50-50. And this is what happens. The victims and that, the ones that's been hurt keeps getting victimized until they get the right person. And then what happens is innocent people wind up going to prison. And then the ones that sit there for a while until they wind up getting the right person. And then sometimes they don't get the right person. I mean, I'm not saying 100% that it is him. I'm not saying it's 100%,
right.
Pookie Bear, Ray Ray, Momo, JoJo. You know what I'm saying?
Sure.
But I'm just saying, though, he did know the ins and the outs because they did state that he had been to that dorm before. That had been mentioned.
The house, that was debunked. They said they made a statement that
Oh,
he
I
was
didn't
there.
know that it had been done. Because
Oh,
I never heard that it had been debunked, sir.
they threw a bunch of that stuff out. First they tried to say that he was stalking them, while the prosecution themselves stated that wasn't true, so that's out. Then
Okay.
the 12 pings that popped up, they tried to say that that was what it was, and that was tossed out. That doesn't exist like that anymore. Then they're saying that he touched the Wi-Fi or something. That was debunked. That's not true either. So all of that stuff that they threw out there left nothing to prove that this man did this other than his DNA being on that sheet. And I question that now. When I found out that there was a swab sent over for testing and not the sheet itself, I don't trust that at that point now at all. Based on everything else that's come out over the past month, we've been lied to. And it's proven that there's been lies. Okay.
That's basically like a he said, she said, they said, cow jumped over the moon, pretty much then.
Pretty much, you can call it that. Yeah. It's a
Right.
mess. It's a big mess. And they're still trying to stand by this.
Well,
And
look at I mean, no disrespect, but look at the Doubtfire case, and I'm sure
I know.
yeah.
Yeah,
Sorry. Look how many people are pissed off at that case. And check this out. How do you go to prison with no DNA, no nothing, but you go to prison? Tell me how you go with no nothing. Come on. Please,
this is
someone
Delphi.
speak up.
This is Delphi 2.0. I've been saying that for about a month now. This is absolutely that case there. We just watched yesterday. We watched the interrogation. They absolutely wrapped him up and put a bow on top of him. Period. That man, in my opinion, is absolutely has
There
nothing to
was
do
no
with it.
DNA. There
Nothing.
was
Nothing.
nothing. And all that guy did was just go and talk to the cops.
He
That's
offered
all
it up
that he.
himself. Yes. Yes,
But
he
if
did.
you go back and you watch the videos, okay, there's a YouTube. Excuse me. I hope this is no disrespect, but her name is Michelle. She's a YouTuber. She's
Oh
got
yeah.
the actual video, and if anyone wants to check it out, and it's the actual video with Mr. Doubtfire. Oh my God, where'd I come up? No, why did I say Mr. Doubtfire? I got that movie on the brain. Sorry. Anyway, it's got him walking down the track, and the girls are in front, And the girls are not screaming. The girls are not yelling or nothing. There's no screaming. There's no nothing. So if the girls were in danger, if they were in trouble, why wouldn't they have screamed or called 911 or anything?
Or maybe ran away.
Exactly. So that's what I'm saying. So if the girls were in trouble or they were in danger, they would have said, they wouldn't have. They would have yelled. They would have screamed. They would have called 911 on their phone or anything. They knew that that gentleman was behind them. Now look, check this out. If I knew for any amount of money there was a man behind me, I would have been A, screaming. B, I would have been running.
Yeah.
But when you're only 4 foot and you're a dwarf, look, us little people do not run. Hello.
Right.
Look, we do not run. Our legs are only the length of our arms. Check this out. Huh.
Yep.
Hello.
No, I can agree. And like I said, they have an unspent bullet, a round that fits to a very common gun that most everybody will have, could have, does have. Okay. There's nothing else that they had to put him in there. Watching the interrogation completely pissed me off. They completely flipped him inside out, turned it upside down. Exactly what he said that they did to him in the interrogation video. And I'll tell you right now, after watching that, the voice that you hear on there is not his. The man that you see walking on the bridge is not him either, because the man on the bridge is too tall to be him. The guy on the bridge is at least 5'10" at the very least, and Richard Allen is a tiny little dude. He's 5'4", not him. So, and he said right then and there, they tried to trap him with that everybody and their mother in Indiana, well, wears Carhartt coats, just like here in Ohio. It's a thing. He said it could have been a black one or a blue one. I had this one, I had that one. And they tried to say, well, you said that you had a black one or a blue one and you were wearing it that day. No, I didn't say that. Stop putting words in my mouth. And that is what they did to that man, the whole thing.
Yeah, they brainwashed him in that. There's another one that they say you can watch. It's called the circus one.
Yeah, that's where we watched that at. Yeah.
Yes.
Yeah, and there's another one we're gonna watch this weekend. The other interview,
I just feel that I mean, no disrespect. I just feel that the justice system has failed us all.
Big time.
And I just feel that right is right, wrong is wrong, and I just feel that things should be done the right way. Like if you go and you rob a convenience store, I feel that it doesn't matter whether if you're white, purple, black, polka dotted, checkered bordered, or whatever color that you may be. I feel that you should get, serve the maximum of what you should serve. And it doesn't matter what color that you may be. It doesn't matter whether if you're rich or poor, or you have no money whatsoever, or if you're a millionaire or a bazillionaire. I do not give two shits a wino or whatever.
I agree.
But it just seems like if you got money, you get out. If you don't have any money, you're sitting there with your, the rest.
Yep, you are right.
Yeah,
you are exactly right.
Yes. And I just don't think that it's right here in America. I don't think it's right.
It's broke. The justice system is broke. We all know that. There are, and please hear me when I say this. There is good law enforcement. It is out there. It exists. I know people. My family have been good law enforcement, but there is a lot of corrupted and bad law enforcement as well.
Yes.
Just as much as the judicial system is corrupted and bad, guys. It's there.
Yeah.
That's why we look at these things and watch these things and talk about these things, because it needs to be seen for what it is. You can't keep just letting it happen. So that's why we do. That is why we do this. And hope that if enough people make enough noise about it, maybe one day it'll stop, or it'll be caught enough to where people are being held accountable for the bullshit that they're doing. That's all I'm saying. So it's a sad situation all the way around. Literally the same exact strategy, damning evidence being used against BK right now. Neither of these items are the weapons. They're items that can be placed anywhere by anyone, not damning. Good point, Candace, and thank you. Oh my God, guys. So at this point, guys, we've been in here for a long time, so I am being paged. I'm gonna have to shut this down, but I plan on coming back in here tonight, maybe to discuss this a little bit more here in a little while. So if anybody would like to jump back in, it'd be great. I'd be grateful to have you here, of course. Shorty, I want to thank you for joining me up
Thank
here.
you for having me, and it's thank
Absolutely.
you in the chat, and everyone take care, and
Yes.
everyone have a good evening. Stay out of trouble. Be kind, or just be plum ornery if you want to. It
There you
doesn't.
go. There you go. Yes, yes, yes. Thank you so
Take
much. And
care,
Hemisphere,
guys.
take care, dear. Hemisphere, thank you so much for joining me as well. Always appreciated, brother. Eddie, you're the man. I appreciate you as well. Sarge, thank you for joining us earlier. Of course, Mama Bear, we love her. It's been a long day with this, but I got so much shit I want to say, you guys. It's driving me nuts. But anyway.
Oh, I got a lot to say too. I just say, and had a
I
chance to
get
get
it.
it all out of me. But
No, I get it. I get it. That's why we'll be doing this for a couple of days, I'm sure, because we got another hearing tomorrow.
yeah, I might come back. If you go back live, I'll come back and be on the panel.
Absolutely. Yeah, you're always welcome, dude. My door's always open to everybody.
Thank you, sir.
Absolutely. I appreciate you very much. Everybody else in the chat, you guys are absolutely amazing. I appreciate you being here the whole day with me for this. All of you guys that hung out, you did it. We got another one tomorrow, and I don't think tomorrow's going to be as long. I pray it's not. So, like I said, I may be back in here in a little while. I got to go do some stuff. We'll see. I got to burn this energy off you guys somehow. So, don't forget, guys, to love each other, love yourselves, and don't change a thing. You guys are the beautiful people. Much love to everybody in here, guys. I wouldn't be here if it wasn't for you, and I do appreciate each and every single one of you. Blue Crew, thank you for everything you do. We all know that I couldn't, wouldn't, or shouldn't do this without you. And that being said, I will see you all very soon. Bye, y'all.
Typing at the speed of light, hunting down the shadows, bringing wrongs to right, digging deep in the data, facts sharp as a knife. With every single story, he's fighting for a life. A voice for the voiceless, he won't stay quiet. Diego's got the fire igniting the fight. True crime revelation shining through the night. With every victim story, he pulls at the strings. A hero in the darkness, hear the truth he brings. Streaming loud and clear, cracking cases, open hearts filled with fear. These channels are beacon in a world gone wrong. He guides us through the chaos, a soldier so strong. The clicks and the lights, they follow his lead. With every new case, he plants a new seed. Sharing their stories, giving hope where it fades. Diego's a warrior through the trials he waits. In a world of silence, he shouts out their names. Diego's got the fire igniting the fight. True crime revelation shining through the night. With every victim story, he pulls at the strings. A hero in the darkness, hear the truth he brings. From the shadows you rise, are streaming loud and clear. True crime revelation shining through the night. With every victim story, he pulls at the strings. A hero in the darkness, hear the truth he brings. Bringing the truth out, answering the call. For every soul forgotten, he's here to stand tall. Diego the genuine, will always give it his all. Diego's got the fire igniting the fight. True crime revelation shining through the night. With every victim story, he pulls at the strings.